All right, y'all, here we go. We should be in here. We should be all set. Welcome, y'all. Welcome back to another YouTube live stream and another episode of the Music Morning Show. We are going to go ahead and get right into it. As y'all know, we are starting the trial. Man, it is going to get crazy. Judge Whitaker's first official day on trial here, and we're going to go ahead and get into it. Trial is already underway. The proceedings have started, and Judge Whitaker is already getting into it. So if y'all haven't yet, please make sure you like the video on your way in, and we're going to go ahead and get started. All right. Good morning, everybody. Shout out to Amy. Good morning.
And the first motion that I am going to deal with is the motion filed by the state, essentially for a gag order on the defense. And with regard to all of these motions, I've read the motions. I've read the responses. If a response was filed, I have read any replies that got filed. So we don't need to take up court time rehashing what's in the motions. They're all well pled. If you have something that you want to add that was not in your written submissions, I'll listen to that. But with regard to the state's motion, which they didn't title for a gag order, but what it essentially is there anything further from the state that you would like the court to consider?
Adrian Love, Your Honor. For the state, Judge, we will rest on the authority that we have presented to the court and point out to the court that since the time of this filing, other instances similar to in nature to the ones that we pointed out to the court have occurred, and we would just simply ask the court to afford the relief requested in the state's motion.
All right, thank you.
And we talked about this the same day that the state filed that motion. Doug Weinstein filed a response later on, and he went and did an interview that same day.
Thank you. And
he does not care.
From the defense who needs to add anything to what's been filed in writing.
Share this out too. Y'all make sure you like the video on your way into.
Good morning, Your Honor. Doug Weinstein for Diamante Kendrick. We will stand on our response. The only other thing I'd like to add is to point the court to the case of WXIA TV v. State 303 Georgia 428, which discusses the presumptive unconstitutionality and issues with gag orders as prior restraint. That case is with respect to the news media, but there is some analogous language in that, and I'd just like to point the court to that. Thank you.
All right, thank you. All right, with regard to this motion, you know, I know that there were some things in it that suggested that certain of the defense lawyers might be running afoul of bar rules, and if they choose to take action that might put them in that kind of a situation, that's kind of
on
up to them. And
exactly.
If there is a complaint filed, then they will have to deal with it. But I think that in regard to the propriety of doing that in this case at this time, I'm going to deny the state's motion.
Let's go.
Obviously, if facts change,
come on, Judge Whitaker,
or the defense at any future time believes that it would be appropriate to consider this issue again, please raise it again. But at this point in time, we are going to move forward without instituting any kind of a restrictive order for speaking with the press in the case.
All right. So she told him, stop crying. Here we go. Shout out to Judge Whitaker.
With regard to the media, I'm just going to remind any of the media actors that are recording this case that the Rule 22s that are in effect in Rule 22 period only permits recording when the judge is on the bench, not during any recesses and not during any bench conference.
And they've been doing a good job with that.
We abide by that from here on out.
I'll see if I can turn this up for y'all too.
Reference some prior live stream that was in some of the motions that were filed and some of the responses, and notice that there were definitely times, at least in what I was seeing, that proceedings were being recorded when court was not in session, and Rule 22 does not allow that. So let's make sure that we stay within the bounds of Rule 22. All right.
Here we go. Off to a good start.
So the next motion that I would like for us to consider is Mr. Williams' motion, and I'm just calling him by who filed it. I know that everybody has joined in on everybody else's motions, but to essentially revisit Judge Krause's factual findings in her recusal order. Mr. Steele, is there anything you want to add to what's in the written filing?
Yes.
Go ahead.
Man of Steel right there. Y'all give it up.
Good morning, Your Honor.
Good morning.
Good morning, everyone. Your Honor, may I just step back for 1 second? Good morning, Madam Court Reporter. I am Brian, B-R-I-A-N, Steele, S-T-E-E-L. And along with the Honorable Keith Adams, represent Mr. Williams. Your Honor, what the Honorable Judge Krause found in her result, we don't take
here we go.
offense to, or we agree with, actually, but when she made some comments which were that this ex parte meeting might have been, I'm not looking at her order, might have been okay if it was done in open court. I strongly, and Mr. Adams, Honorable Mr. Adams, strongly disagree with. And the reasons are in the joint affidavit of Mr. Adams and myself, dated.
Oh, this is getting good. They're coming out swinging today. Is Fanny in the courtroom?
July 8th, 2024.
I don't see her. I don't see a Fanny in there.
What happened here is
Young thug with the green
you
tie.
have a witness, Mr. Copeland. He was sworn on June 7th of 2024, and he invoked a privilege. To my understanding, Your Honor, he did not have a privilege to invoke. The state, and we didn't have notice of it at the time, but the state ordered, or maybe we did have notice. I didn't have the motion, but I had the order, I believe. The state asked the Honorable Recused Court for an use immunity. So nothing that Mr. Copeland can use could be then turned around and prosecuted. So the way I understand the law is that protected anything that Mr. Copeland said was like an umbrella over him, so that anybody, federal courts, they could not use this testimony, but he could still be prosecuted.
Correct.
Which
was messed up.
Somehow, according to the transcript, which is the ex parte hearing transcript, June 10th, 2024, there's the recused judge, Miss Love, Miss Bumpkus, B-U-M-P-U-S.
All right, and let me interrupt you for just a second. I've read the entirety of that ex parte transcript, so I'm familiar with what happened.
So my position is nothing there was good. Everything was wrong. And I believe, as stated in the affidavit and the motion, that there was intimidation put upon the witness. To change his statement, he made it very clear, send me back to the DeKalb County Jail. I'm not testifying. I have a case for the court. And based upon what you just said, if I could just get that case,
okay,
I'll be right back.
Oh, here we go, man. Judge Whitaker says she already knows. She read the ex parte meeting transcripts. What do y'all think is going to happen? Oh, man. This is getting good already. She read the whole transcript. She knows that the DA's office is on some BS. She is ready to go. And she started on time too. I was late. Dang, I'm not usually late like that. Judge Whitaker making me look bad. defendants in there. Shout out to the man of steel. Y'all have to give me some grace. I'm gonna be eating my breakfast. We're starting early, so bear with me.
All right, while Mr. Steele's looking for that particular case, just a heads up to everybody else that's going to be arguing case law. If they want to present a case, try to go ahead now and be getting that at your fingertips, okay?
We got Mr. Weinstein and Yakati over there. She is not playing. That's true.
Is this a case that's not cited in your? Yes. Okay.
Uh-oh. Is she about to pull a Glanville? Call him unprepared? Come on, Brian. Get it together, man. Yeah, you know what's up, Amy. It's Blueberry.
Thank you.
Blueberry smoothie, blueberry bagel. Thank you to everybody who's in here too. We've got over 30,000 people in here. Can y'all like the video?
I just provide to this honorable court and prosecution in one copy to the Honorable Douglas Weinstein of Archer, A-R-C-H-E-R versus Maryland. It is 859A, as in at least a 2D 210 2004 case. And on starting on page 6 of 22, Your Honor, of the copy I've given the parties, on the right-hand side, right in the center, the Maryland court explains that here Bailey had been convicted, sentenced, and the time for filing an application for leave to appeal his guilty plea had expired. Thus, he had no Fifth Amendment privilege to refuse to testify. Contempt proceedings were therefore an appropriate response to Bailey's refusal to testify. So it's the same situation, except he pled guilty. Mr. Copeland was never charged. He's called an unindicted co-conspirator. That's announced by the state. On page 10 of 22, the appellate court in our sister state goes through what happened with the judge. Now, this is not ex parte. This is in open court. So this gets to what you asked about Judge Krause's findings. And what the judge said on page 10 of 22 on the left-hand side in the center, first full paragraph, we find that the trial judge's efforts to persuade the witness to testify went too far. If Bailey persisted in his refusal to testify, Judge Previs, P-R-E-V-A-S, had the option of either initiating direct contempt proceedings or constructive contempt proceedings. The authority to initiate contempt proceedings, however, is not a license to intimidate a witness into testifying. The purpose of the contempt power is to provide a means for a judge to uphold the dignity and integrity of the judicial process. And then skipping down to the next paragraph, similarly,
Can I interrupt you? And let's not skip down, because I think that part we're skipping is maybe important too, because it talks about the specifics of what that judge did in this case. So what is that?
Okay, well, he did a lot of things, but what the court is referring to, under the circumstances of this case, the phone call to another judge in the presence of the witness, the threat of life imprisonment as a sanction for contempt, and the suggestion that the other judge will give Bailey the longest possible penalty for contempt detracted from the dignity and integrity of the judicial process rather than uphold it. Similarly, it was unnecessary and excessive to instruct Bailey on how he could testify in the Archer case. Mr. Archer was the one on trial. Bailey was represented by counsel who could have advised him concerning the various testimonial options if that was deemed necessary under the circumstances. Even if Bailey was unrepresented, it was not in the province of the court to suggest to the witness how he could testify to avoid a contempt sanction or how to allay his fears of testifying. In either case, it was not the function of the trial judge to suggest to the witness that he could testify favorably to the defendant, Archer. Specifically, Judge Purvis advised Bailey that he could testify favorably to the defendant, and there is nothing that anybody can do to punish him for that. That admonition was incorrect because Bailey could be prosecuted for perjury. So it goes on. And there's great language. And the reason I use it, I understand it's not binding precedent, is it's hard to find a case like ours, but I searched and I found this. And what happened here, as the court is aware, just to highlight, because I heard what you said, the witness said, can I have 2 weeks to go home on house arrest instead of in the county jail? His child was having a birthday. That was a big deal to him.
Yeah, that was
And then
tough.
I'll make a decision whether to testify or not. I want to think about it. That answer should be from the court, because the court can do anything in contempt. It can give a fine. It can give weekends. It can give house arrest. It could do nothing. It could say you satisfy your contempt. That answer to that question was done by Ms. Hilton in front of the judge. Ms. Hilton said, no, you cannot. You have to go to jail. I find that offensive. This is my words. And that's why I'm disagreeing with Judge Krause. Number two, Mr. Copeland said in that meeting, everything I said was a lie. I've never told the truth in my life until this statement right now. That is like bullseye of Brady. It was hidden from us. It came out later, but it was attempted to be hidden.
All right, so that's in the context of another motion of yours, right? So let's focus on this motion for now.
My point is, nothing was done appropriate. I mean, and I don't want to get into, and the state actually filed a motion later saying the Honorable Judge Krause already ruled on this. I didn't know that they would do that, but I already said, I'm not accepting those factual findings, respectfully, because they're wrong. A, and B, they weren't even needed for the finding. Another issue that came up is Mr. Copeland was told how to testify. I don't know how this happened because I don't have the questions. But Judge Glanville told the state in front of Mr. Copeland and his lawyer, didn't you give Mr. Copeland the state's questions that they're going to ask him? I don't have those questions. The judge said to Mr. Copeland, remember what Miss Love told you. Unless you tell a big whopper of a lie, these are not quotes, you're not going to get in trouble. That's not in the transcript. So something happened outside the transcript. Those are just a few issues. There are more. They're all in our affidavit. But those are a few issues that when Judge Krause said everything that was done, if it was done in open court, was appropriate, everything that was done is intimidating a witness. And it changes the complexity of the case. Because what you will find out is Kenneth Copeland, these are my words, made misstatements to law enforcement. He made 6 statements. They're all audio, video recorded, except for 2.
And he said he did it too. He was saying whatever he needed to get out.
Track over 16 hours. The judge told him, and Miss Hilton told him, and Mr. Copeland said, you previously told me, meaning Miss Hilton, I could just say I don't remember. I don't recall. And the judge said, yeah, you won't get in trouble for that. Well, what that does as under Georgia law is that triggers a prior inconsistent statement, which is all that the state wants him. Mr. Copeland is just here for his prior consistent or inconsistent statements. And that's what happened in the Archer case. That's why they're saying the judge said to Mr. Bailey, you can even testify for Mr. Archer. You won't get in trouble because, and it explains in the Maryland case, because that would trigger and open the door to prior statements, which is all the state wanted. So to me, as found by the Maryland court, this is intimidation. There was nothing appropriate. And the Honorable Judge Krause, I'm confident, did not have this case, but I respectfully disagree. And that's why I wrote that motion.
All right. Anybody else? And I know that there is another, or there are a couple more motions for mistrial based on the ex parte that talk about coercion and things like that. And I'd rather take those up in the context of those motions. So if that's what you want to argue, hold off. Otherwise, come on up.
Your Honor, good morning.
Oh, here we go. Mr. Sharp.
Shannon Stillwell. Of course, under the Harvey rule, I have joined Mr. Steele in his motion. I would like to, I I guess I disagree with Mr. Steele in one small aspect. He is seeking to challenge the findings of Judge Krause, the factual findings, is the way he's articulated it. And I too have concerns about the order in the respect that it suggests that the ex parte meeting was or could potentially be appropriate. I don't believe it was appropriate at all, and I know that we're going to get further into that. But, Your Honor, I would my disagreement in where I want to veer off from what Mr. Steele was saying is that I don't believe that they're factual findings. They're not necessary for her.
Oh man,
ruling.
he's taking it another step.
I believe that they're mere dicta. I don't believe that they're binding on you at all. What Judge Krause's order said, I believe that you independently can take a look at the transcript and make your own determination about whether the ex parte meeting had an appearance of impropriety or whether it was in fact improper, which it certainly was. So I just object to the characterization of these as factual findings because I don't believe that they are. I believe that they're merely dicta, and I believe that you're able to make that assessment on your own. Should you view them as factual findings, I, of course, join Mr. Steele in his objection to those quote-unquote findings. That's it. Thank you.
All right. Anybody
Man,
else?
they're hitting them with the 1-2. Max Sharp is saying, hey, I get what Brian Steele is saying, but from the get-go, from the beginning of this, everything was wrong. A lot of this is all messed up. Kind of going to what Brian said, but he's just piling on. It's crazy.
All right, I'll hear from the state.
Look at Miss Love. She's mad already.
And I know you haven't had a chance to see and absorb the Arnold rule. I think Arnold, the case that Mr. Steele just Archer shared with us before now. But
wow,
Your Honor, I will use it as he has presented and just point out the most obvious omissions and distinctions that I see present with the Archer case. Mr. Steele stated to the court that Mr. Copeland had no privilege to invoke. He spoke about what did or did not happen during the meeting, during the hearing in chambers. I would ask that the court, as the court has already read the transcript, that the court take note of the differences between what occurred in the hearing and what Mr. Steele has represented to the court. As it relates to intimidation, Mr. Steele asserts that a statement made by Ms. Hilton essentially is part of what makes the hearing improper. The state has cited in its motion or its response to the court cases that support the state's position that this hearing was not improper. Essentially, in order for, as this is a motion to challenge factual findings, I'll speak to the factual findings that
stay on point, Miss Love. What is she talking about?
Again, Mr. Steele cites that Judge Krause's finding, the way he said it, if it had been made in open court, it would have been proper. The court.
Right, why don't I just put on the record, because I've got Judge Krause's order right in front of me, exactly what it is that I think we're talking about. I believe, and Mr. Steele, you can correct me if I'm wrong, but I think
look at
that
the attitude.
The factual finding, that's the second one you're challenging.
She is
even as
big
factual
man.
Finding is Judge Krause's statement. It is worth noting that this court generally agrees with Judge Glanville's assessment of the propriety of the ex parte meeting. While the meeting could have and perhaps should have taken place in open court, nothing about the fact of the meeting or the substance discussed was inherently improper. Is that what we're talking about? Yes. All right.
So how's she talking about Brian Steele and then she just jumps to
the fact that we
what Max Sharp
The court
said.
has at its disposal the
I'm
transcript
confused.
of the hearing, Your Honor. And given the case law that the state has cited to the court, specifically, Your Honor, Allen v. State, 336 Georgia App 80 at 81, citing King versus the state, a Georgia Supreme Court case.
We looked at that yesterday.
The site is 273 Georgia 258 at 264 through 265 as authority for its ruling that appellant had no standing to contest the grant of use immunity to a witness. And King versus the state itself ruled after an appellate complained that the trial court acted improperly by conducting a brief hearing outside his presence concerning the state's request for an order compelling a witness to testify at trial and confirming the use and derivative use immunity that would apply to that compelled testimony, that the hearing in question was not a part of the proceedings against appellant, and that while appellant, quote, might have preferred that a key witness not be ordered to testify truthfully in his trial, there is nothing in Georgia law that would have permitted him to object to the state's request for the order or that would suggest that appellant's rights were the subject matter under consideration and that appellant had no standing to address the matter of the hearing outside his presence. I bring up those two cases, Your Honor, as well as Gilbert versus the state, and that site for Gilbert, Your Honor.
Shout out to Gilbert. I have no idea what Miss Love states. She's basically reading their response.
Is 306 Georgia App 776 at 777.
Which says,
notwithstanding Gilbert's waiver, however, his argument is without merit because Gilbert has no standing to contest the grant of use immunity to Lang. The court again cited King and pointed out how the defendant there had argued that the trial court erred by conducting a hearing outside of his presence to determine whether a witness should be compelled to testify against him in exchange for use and derivative use immunity. They go on, this court goes on to cite the portion of King that I just read to the court and goes on to say, on the contrary, the trial court was obliged to consider whether the testimony was necessary to the public interest, a matter which the defendant had no standing to address. In this particular instance, of course, there is the distinction that Mr. Copeland had invoked his right to not testify at a point where
he had already been given immunity. We got it. Okay.
I'll agree with Mr. Steele. There wasn't a privilege to invoke. The point at which he said, I plead the fifth, is when he was asked, I believe, his age in years. The concern that
we were all late, Variant. You're good.
The concerns that we had, we presented to the court, and mainly it was that Mr. Copeland, as is recorded in the transcripts of the July 10th proceedings in open court, that Mr. Copeland had questions that he was attempting to ask the prosecutor, Ms. Hilton, and the person representing Mr. Copeland would not afford him that ability while we were just outside the courtroom. And Mr. Copeland was then called in with the jury in the box without having had the opportunity to have those questions answered.
Was he sworn in?
The hearing,
why was he answering questions?
Reflected in the transcript, dealt solely with Mr. Copeland's rights, what he faced, what his obligations were. The state's action of moving the court to compel Mr. Copeland to testify is what precipitated that chain of events that led to that hearing in chambers. And we wanted to ensure that Mr. Copeland was aware of whatever it was that he had sought to gain clarity about before he was forced to come in before the jury. So
Yes.
I just say opposing proper that she proffers.
Yeah, I don't know what she's talking about. Shout out to Max.
She is. She would have to be sworn in and testify in such a process.
All right, thank you. So I have read the transcript, and the transcript is the best evidence of what happened there. And what we're dealing with is whether I can and or should reconsider, I guess, the factual findings made in Judge Krause's order.
So the state's position, Your Honor, is just as Judge Krause was the
I don't know what she's saying.
Court tasked with making a determination regarding recusal. The court has been tasked with the responsibility, the assignment of continuing the trial. Judge Krause's responsibilities we submit to the court are Judge Krause's, not this court's. Just as each court that at each step in this process has its own set of duties, that one belonged to Judge Krause.
Okay.
So we would ask that the court deny the motion to challenge the factual findings of Judge Krause.
Anything
So
else?
basically what Miss Love is saying, she said, can y'all stay out of Judge Krause's business? It doesn't matter that she threw Glanville a bone and she said, okay, well, he was handling the case fine, but he's out of here. All that to say it, to say that. Shout out to y'all. Y'all like the video.
Has there ever been an attorney invited to talk who didn't take the opportunity?
I took a pass a couple of times, Your Honor. Doug Weinstein for Mr. Kendrick. The only thing I want to add is that the King case and the Gilbert case are about a different circumstance than we are objecting to and complaining about here.
Correct.
That
No
is a
ex
hearing
parte
about
meeting.
The issue of whether the immunity should be granted by the court. Presumably that was done in this case sometime prior to Mr. Copeland's testimony on the 7th. What we are concerned about, object to, believe violate our client's rights, is the ex parte meeting that took place in Chambers on the 10th.
Exactly.
After that immunity decision was made, at least just speaking with respect to my client, Mr. Kendrick.
Okay.
Exactly.
Thank you.
And that's what we have been saying. The ex parte meeting changes everything.
All right. With regard to just this particular motion, which is styled a motion to challenge essentially Judge Krause's factual findings in her recusal order. It appears to me to ask this court to almost sit as a reviewing court and find certain factual findings to be erroneous. And this court doesn't have an ability to do that. The time to have filed or sought a certificate of immediate review has passed. I can't really sit as a reviewing court over a fellow superior court's order. To the extent that it is a motion to reconsider that court's order, that's a little bit closer to something that I might be able to do, but
she's going to deny
I
this.
can't really do that either. That, as Ms. Love correctly pointed out, was a motion to recuse Judge Glanville. It was before Judge Krause, not this judge, and she granted the relief that the defense sought. I understand that the defense does not like some of what might be factual findings in there. There are other motions before this court right now for mistrial based on that, and I think it is more appropriate that I consider them in the context of that than going back and essentially undoing potential factual findings made by Judge Krause. I think I agree with Mr. Sharp that this is probably dicta anyway, in that the essential holding that the court made was that the recusal was based on Judge Glanville's engaging essentially while making a ruling on the motion to recuse and making kind of more than just the minimal necessary findings in his ruling. But I'm not going to reconsider Judge Krause's factual findings, so I am going to deny that particular motion, understanding that we still have other motions for mistrial to take up where some of the arguments y'all made just now might be more appropriately considered.
Yeah, I agree with that point too. I'm with Judge Krause not Judge Krause, Judge Whitaker on that one. It's a tough place to be. I mean, asking another judge, a judge to review a motion is not Judge Whitaker's place in this case. So I think the state made a great point. She's going with it. I don't have a problem with that.
All right.
You got to take it up to a higher court.
So
some of y'all were saying
that
in
actually,
the chat.
The next motion I'm going to take up is the motion filed by Mr. Williams that has a very long style, but that essentially asks that any other ex partes be revealed, that a neutral judicial officer take a look at everything in the case that has been sealed and make sure that it is above board. And then for a mistrial based on the alleged judicial misconduct that occurred during the particular ex parte that was the 10th of June, and prosecutorial misconduct there and prior to that. So I got from the clerk's office every sealed filing from the state or any of the defendants in any
she
of
looked at all the
these
filings.
6
Jeez.
defendants' cases. I've looked at all of them. There's nothing improper about any of them. I refiled them. The order that it accompanies the resealing, I'm sorry, not refiled them, resealed them, actually delineates each of the things that I looked at or the dates of each of those sealed filings. I'll note that a lot of those ex partes were defense ex partes. There's nothing wrong necessarily with something being done ex parte. We're kind of talking about this June 10th ex parte as though, ooh, that is such a horrible thing. And it may be, but
it's with the sworn witness,
in and of itself
Judge
is
Whitaker.
not necessarily a bad thing, and both sides have appropriately held ex parte communications about things that should be ex parte with Judge Glanville prior to this. So there's nothing in any of those sealed filings that the other side needs to see at this point or that was improper in my determination. All right.
So she said Brian Steele ain't getting those ex parte
the defense asking
transcripts.
Whether there have been any other ex partes that we don't know about. And so I'm going to ask everybody, and y'all know what ex partes you had with Judge Glanville, and you know what filings got made. And so is there any ex parte that occurred that is not connected to one of those sealed filings? And I'll ask the state first.
No, Your Honor.
Your Honor, not being certain whether the sealed filings include the transcript of the request from the state to have the hearing with Mr. Copeland, and not certain whether or not those sealed filings contain that.
Okay.
I can't say, but the state requested that we address the matter of Mr. Copeland's representation.
All right. And was that done in writing or was that oral?
The request was done orally with the court reporter there. Okay. We requested that the court allow us to address the matter and that it be taken down for the record.
Okay. All right. Anything beyond that?
Yes, there was also the state's request for a
got more ex parte meetings
for one of the.
I think those are all reflected, and you may want to go back and look, but I know that there were material witness warrant requests from several different parties in the case.
Okay. Okay.
All right.
So those are the ex parte matters that we address with the court.
Okay. Thank you. Mr. Weinstein, anything? Okay. Mr. Carlton, Mr. Matthews. Okay. Mr. Steele.
Brian Steele, you had some ex parte meetings. Don't let me find
My
out.
best memory, which I believe is accurate, there were 2 meetings with recused Judge Glanville. One was during voir dire. It is going to be the day, I could get you the date, but it's going to be the day that law enforcement executed a search warrant for the computer of the Honorable Eric Johnson. He's a lawyer in the case who's severed out now.
Okay. All right.
And that was announced in open court. I asked recused Judge Glanville whether we can have an ex parte.
He said the
parties
Honorable
were here, and then everyone went. So when I say everyone,
come on, Brian.
Went into chambers behind, and there was conversation in front of a court reporter.
All right. And when you say all the people here, does that include?
He said the Honorable, I mean the
So
recused.
was here.
All of the defense attorneys.
And the state was here when I announced that we'd
Okay.
like to meet ex parte. The judge, former judge reconvened. Our former
Man
judge
is petty.
reconvened.
Okay.
We went into the chambers
Oh my
here. So
God.
I have no idea if that's something you looked at or not.
And I don't know whether that's anything I looked at because that would have concerned a severed defendant. I would imagine it's in that case and not any of these 6 defendants. And I only looked at what was in these 6 defendants' cases.
I can't
But-
answer.
Okay.
And when I say who was here, yes. Honorable Mr.
Okay.
Matthews, Mr. Weinstein, Mr. Harvey, I assume Ms. Westmoreland, she's shaking her head. Misty Williams, I know Mr. Adams was next to me, Mr. Sharp, and I presume Mr. Bucks. He's saying his head, yes. And the second one was also asked in open court for a meeting with the recused judge ex parte, and that was on the day before we're coming up to a man named Mr. White, like the color, was going to testify, and we had it at the bench where the court is, and that was Mr. Sharp, Mr. Matthews, Misty Williams, myself.
Yeah, but you weren't talking with the sworn witness
Mr.
without the
Adams.
state
And if I
there.
my memory's wrong. I'd like them to correct me. That's who I remember being there, and it was on the record.
Okay.
So I don't know if you saw anything about that.
All right.
And that was the total that I've had with.
All right. Thank you.
Did y'all hear that? He said the
Mr.
honorable,
Harvey.
I mean the recused.
Just to be on the safe side,
Jeez.
we had a in-camera meeting with Judge Glanville. When I say meeting, it was not ex parte, it was me, Ms. Westmoreland, and I believe A.E.A. Hilton. But it concerned a scheduling conflict in federal court
Okay.
that I had, and we resolved that. I just want to make sure that.
All right. I appreciate it. Thank you. Mr. Short.
Let's see. Max is gonna mix it up a little bit.
Your Honor, to the best of my recollection, I recall being with Mr. Steele in the announced ex parte regarding that gentleman, Mr. White. I also believe there was an ex parte regarding another permission to interview a separate witness who was unrepresented at the time. I believe that probably is reflected in the sealed records. I can't recall if Mr. Steele was with me or not, but that also occurred, and that would have been before the jury was sworn. That was late 2022.
Okay. Thank you.
Mr. Steele is indicating that he was present.
All right. Okay, so that takes care of that part of that motion. unless
Okay, moving
anybody
on to the
wants
next one.
to inquire further as to any of those. Okay.
Oh, Your Honor, what's confusing to me, Your Honor, is in the transcript of the June 10th ex parte meeting that we've focused on, there is within the transcript, there's a clear indication that Judge Glanville is aware of, as Mr. Steele alluded to, questions that the state is in possession of, that they seek answers from Mr. Copeland about, and wish to pass these questions on to him. There is nothing in the transcript that indicates a discussion between, I believe it was Ms. Hilton that was in possession of this list of questions. There's nothing in the transcript that indicates a conversation that even suggests how Judge Glanville would be aware of these questions, the existence of these questions. And it just leads me to the inescapable conclusion that either the transcript is not complete or there was a separate meeting that occurred, because there's just no context to it. It just doesn't make any sense to me logically. So that's my...
I knew it. I knew Max was going to come in here and mix it up. I said, there's no way he gets in front of Judge Whitaker without mixing something up in here. Come on, man.
So I read that part of the transcript, and obviously I wasn't there, but when I read it, I just thought, I think Judge Glanville used to be a prosecutor, and he assumed surely you must have given them a list of questions. Now, I have no idea whether that's if it was just like, surely you have a list of questions, or if there had been a prior conversation, and I will ask Ms. Love that.
Your Honor, I believe that since Ms. Hilton was the one present.
Or Ms. Hilton.
But I can say that I did hear Judge Glanville, I believe, in open court say something similar to that, but I will allow Ms. Hilton to address the specific.
All right. Ms. Hilton, was there some basis from something that had already occurred for Judge Glanville to have asked that?
No, Your Honor. We were very sure to only talk about what was happening, which was getting Mr. Copeland purged from his contempt. So I made it clear that we weren't going to talk about anything substantive, and to talk to the judge about any questions to me would have been substantive. So we never talked about any questions with the judge prior to Judge Glanville saying that during the meeting.
All right. And was everything that occurred in that meeting, other than the times when
she's testifying right now? Get her on the stand.
Judge Glanville stepped out so that Mr. Copeland could talk to his own attorney, and I believe talk to y'all. Was everything else recorded?
Yes, Your Honor.
Okay. From the outset of that meeting?
From the outset of the time that I entered the room, everything is recorded.
Right, because you weren't there at the beginning of it.
Correct.
You did not have a conversation with Judge Glanville prior to when you came into chambers and it was being taken down?
Outside of the normal,
how are you doing? How was lunch? Yes.
Correct.
Okay. And Ms. Love, you were in there at the outset. Was it recorded, taken down from the outset?
Yes.
Okay.
Man, no way. Come on.
Stop the cap. As I stated earlier,
There's no way.
Other instance that we spoke on that was also taken down.
Okay. All right. And that was earlier that same morning?
I think it was the Friday.
The Friday before? Okay. All right.
That's correct, Paige.
All right. So based on that, I don't find that there was any other untranscribed prior meeting between the state and Judge Glanville regarding Mr. Copeland and what they discussed in that June 10th ex parte. All right, another part of this motion.
All right, that's another L for the defense.
Is a list of purported slights and misrepresentations by Ms. Love that I'm not going to go through in more detail. They're in the motion. I'm just going to say, Ms. Love, make sure that your representations to the court and in court are accurate and professional.
Ooh. Hold on. Wow, that switched up quick. Let me run that back real quick.
Slights and misrepresentations by Ms. Love that I'm not going to go through in more detail.
Slights and misrepresentations.
I'm just going to say, Ms. Love, make sure that your representations to the court and in court are accurate and professional. All right?
I will continue to do that as I have.
All right.
The court require all parties to make certain that.
Okay. All right. With regard to Judge Glanville's comments, I mean, he's off the case at this point. If we want to endeavor to craft some sort of a instruction to the jury, you know, I'll consider something that y'all want to present to me. But I know in particular, Mr. Steele, you took issue with apparently at some point Judge Glanville used some adjectives about you, specifically unprofessional and
unprofessional and unprepared. Yep.
Are bothersome to you, and I can understand that. I would also say that not only is that in the past, but if that was in front of the jury can see for themselves how you present, whether you're professional, whether you're prepared. And so that ought to take care of that. And this court is going to instruct the jury, just like is done in every case, that nothing that the judge says, no matter whether it's this judge or the prior judge, is evidence. It's not supposed to indicate any kind of a bias one way or another. And so I'll give those curative or those instructions anyway. And if you want something additionally curative wise, I'm willing to entertain that as well. Okay.
Yeah, I don't think there's anything more to say there.
Given that Judge Glanville is now
gone,
recused from this case anyway, and I have instructed Ms. Love to conduct herself with professionalism. I am going to deny the motion for mistrial as it is sought and on the bases on which it is sought in this motion.
Okay, so
yes,
Brian Steele, no mistrial.
Whether the court is finding that there were any unprofessional or
she got her feelings hurt. Come on, Miss Love. Let it go. Let it go. Move on. She is so. Let it go. Let it go, Miss Love. Just be professional. Just say okay and move on. She has just got to be right. This is crazy. It's even a worse look.
Yes. I just asked for clarification whether the court is.
Let it go.
Finding that there were any unprofessional or.
I am not making any such finding.
Thank you.
Yes.
Come on, man.
Maybe I was lost for a second. I think we switched to a place where I didn't believe we were at, or I didn't understand the discussing regarding a mistrial. I didn't really understand us to be at that point in the motions yet. And I just wanted to be clear for the record, to the extent that a mistrial was denied. Mr. Stillwell, it has been we never requested a mistrial.
Okay.
And
that's true, he did not.
Denied. I just want to be clear that Mr. Stillwell has not requested a mistrial. And when we were going to move on to Mr. Harvey's specific request for a mistrial.
Yeah, I hadn't gotten to that one yet. Okay. All right. I appreciate that.
I just want to make that clear for the record.
Okay. Thank you.
Just relax, Max. This is crazy. I can't believe she said that to Miss Love.
So now
said get it together.
We get to the motion to disqualify attorneys Love and Hilton, the two of the main ADA prosecutors in this case.
This is going to be good.
And the basis for that, this is also filed by Mr. Williams, is that they assert a need to cross-examine Mr. Copeland, attorneys Love and Hilton, and Judge Glanville with regard to the ex parte. Anything that, Mr. Steele, you want to argue that's not in your motion with regard to this? And I do have a question for you about one thing that you said.
Yeah, get him up out of there. Dang, look at what does Brian still got going on over there? He got a whole book.
Yes, Your Honor.
You want me to ask my question first?
Whatever you tell me.
So in your paragraph 3, you assert that Judge Glanville provided legally incorrect information to Mr. Copeland. I just want to make sure I'm clear as to what you assert that legally incorrect information is.
Okay. So going back to what you've read and digested, June 10th, 2024 ex parte meeting, the use immunity, as we discussed earlier, just protects Mr. Copeland. What Prosecutor Hilton and what Judge Glanville were telling Mr. Copeland was, you can say lies, as long as they're not big lies, and you will not be prosecuted. He could be prosecuted for perjury and false statements.
Okay, and when you say that, do
That's
you
true.
mean when it was mentioned that if you say, I don't remember,
No.
you
it said
can't be
it-
prosecuted?
No, I have to get the transcript in front of me, but it was as long as Miss Love told you, which is not in the transcript, but the Judge Glanville said, as Miss Love previously told you, remember is the word used, unless it's a big whopper of a lie, you will not be prosecuted.
Do you have access to the transcript right now?
May I step back?
Yes, and of course, I thought I brought it up here with me too, but I don't seem to have it in front of me either.
All right, Brian, come on now. We got to be prepared, man.
Can you go see if it's on my desk somewhere? I don't know how it couldn't be here, but thanks.
Yeah, she told Woody he couldn't be prosecuted. Only thing he wasn't allowed to say is that he killed Big Nut. The judge is unprepared. We have some unprofessional, unprepared people in the courtroom today. See if we can fast forward.
I'll be somewhere. Just room.
From the transcript of the ex parte hearing, June 10th, 2024, he directed me to page 40.
They need to get some of us in there. We'll tell them where it is.
Line 20. What will get you in trouble is you not, is you just invoking your Fifth Amendment privilege because you have been given immunity. Or as Ms. Love said this morning, remember, Ms. Love said, if you lie, if you overtly lie about something, like if you tell a bold-faced, not big whopper, bold-faced whopper,
Bold-faced whopper, yeah.
then they can indict you on that particular charge. I mean, that particular false statement. And then Mr. Copeland said that's what they're going to do. Then there's conversation by Ms. Bumpkus. That is what I was saying. You will be right back here. Then Ms. Hilton said on page 41, line 5.
Bumpkus.
But if you say something that you know that you did not do, like you admit to something you know you did not do, whether you, and then Mr. Copeland said, like murder, don't have like no statute of limitations, right? Ms. Hilton said on line 10. But if you didn't do it, I can't charge you with something you didn't do because I don't have any other evidence but you saying it. Mr. Copeland saying, but y'all don't like ... His lawyer said, you could charge him with false statements and he will be back in jail. That's what I'm trying to say. And then Ms. Hilton on line 17 said, but if I know that you're lying about that, I do not intend to do that. If I know right now he's lying, I know he's lying, I'm not going to charge you because I don't know your reason for doing that. But I'm not going to charge you when I know you didn't do what you were trying to say you did now. And that can be part of this. I know you didn't do it. And the judge is there. So I hope that's answered your question. There's another space that I can find. I just need a second. But
yeah, that was
it's
messed
the
up that
judge
she said
saying
that.
you won't get in trouble. He says that throughout. You can say you don't recall. You won't get in trouble. There's also a place in here
Can't do that.
where the judge tells Mr. Copeland and Ms. Hilton that the statute of limitations, this is Ms. Hilton, the statute of limitations has run. In federal court, she says, I looked it up. In federal court, it's a 5-year statute of limitations. In Georgia, it's a 4-year statute of limitations. If I could get that site for you, I'll tell you exactly where it is. What page?
Yep, he's right.
I'm being told 24, Your Honor, but let me check. Mr. Adams said 24 going into 25. Your Honor. On page 24, line 12 is what I see. Ms. Hilton says, and what we'll say, and Mr. Copeland and I, we've talked about this. I'm not sure what your concerns are, what concerns that you expressed to Mr. Melnick last week. But if you are, if any of your concerns deal with being locked up for anything, you can't. Like there's nothing that can happen. The feds, Ms. Bumpkus interrupts. Well, that's not, Ms. Hilton interrupts. It is true. Ms. Bumpkus, said, no, I said,
come on,
that's
man.
not his concern. Ms. Hilton said, if it is his if it's a concern for his safety, we need to know that. Like that's not expressed. So we don't know what the concern is that we can try to resolve the concern. This is what I'm saying, Mr. Copeland and I have had conversations before going to page 25, Your Honor, and here it is. I understand some of his concerns is potential criminal liability, hence why we gave you immunity. The federal statute of limitations done. The state statute of limitations done. So there is nothing, like I researched it this weekend again, both those statute of limitations for what you and I talked about, which is a 2015 or before done. You cannot be prosecuted for anything you testify federally or statewide, immune, period. So if that's a concern, there is none because you cannot be prosecuted. The federal statute of limitations is 5 years. So anything 2015, 5 years would have been 2020. Anything statewide is 4 years. It would have been 2019 finished. Your Honor, that's just not true. He's an unindicted co-conspirator in this case.
It sounds to me like they're talking about some kind of particular crime he might or might not have committed that he might be testifying about, and whether.
And where is that in the transcript?
Murder, because as he recognized, murder has no statute of limitations. But that sounded like it was a really particular crime.
You can't tell a person. I wouldn't tell a person. How about that? You can't be prosecuted because statute of limitations ran when you know he could be prosecuted in our indictment.
Exactly.
The state is saying,
agreed.
Yeah.
That appears to me to be talking about something very particular that they've had, like a particular crime they had conversations about, and not overall broadly. You can't be prosecuted for anything.
Yeah, but Judge Whitaker, what about the I did these crimes? Why is that not being brought up? Why aren't they talking about the I did these crimes? Brian, you gotta ask about that.
Okay.
I don't read it like that. All so right. On the next page 26, it's again, Ms. Hilton, line 2, you will not. This order, I don't know if. Can I interrupt
you for just a second,
sure.
too? And I'm sorry, and I do want to hear, but is there anything else that Judge Glanville said that you believe is legally incorrect information?
Yes.
Okay, because I want you to address that.
We need you to testify. Why do we need you to testify?
Uh-oh.
That Mr. Copeland had to stay in custody till all 26 criminally accused have their case disposed of. That's not true.
Okay.
That's wrong.
Yeah.
Don't get him riled up, Judge Whitaker. Brian Steele's getting riled up. We got to relax. And thank y'all for liking the video so far too.
It's on page 36 of the transcript, lines 3 through, the discussion's kind of lines 3 through 9.
At some point, civil contempt becomes punitive. Civil contempt is supposed to make the person do the act. If the person's not doing the act, at some point, it's just not effective. So it has to be then given a date certain. You can't just hold a human being in custody until all 26 people, some of them don't have lawyers forever.
Yeah.
That's what Judge Glanville said. That's the problem. So I'm just being transparent. We're going to have a situation where Mr. Copeland's testifying. At some point, I'm going to be able to ask questions. I'm going to ask him, was there a time on June 10th, 2015 that you found yourself in an office with a judge?
Objection, relevance. And there went that. Might be another L for the defense. We'll see.
Was this person who I'm pointing at there? He'll say, I believe no. But the transcript says, exactly. You spoke with Ms. Love earlier.
If we get to that, that may be something that you are able to examine him about. And I do think that, you have the transcript, and I know everybody has said, oh, there was Brady in there. Y'all got it all now. So it's not Brady anymore. If it even was before, y'all have it. You can use it at trial. I think you can appropriately examine Mr. Copeland if he decides to testify on some, maybe all of the things that happen in there. That may be something we have to hash out a little bit more. But let's not get ahead of ourselves. So with regard to legally incorrect information that the judge gave to Mr. Copeland, the two, page 40, 41, 24, 25, and then the one that I cited that you mentioned about all of, you may have to stay in jail till all of the co-defendants trials on page 36. Anything else?
We need you to testify. Nobody needs him to testify. He could do whatever, it's America. He could do whatever he wants. He could sit in a jail.
Okay.
He has to pay penalty.
That was a really weird statement.
And they also tell him how to testify.
Mm-hmm.
Judge Glanville tells the lawyer first. If you remember, I could get you the transcript. You remember, you're shaking your head. Judge Glanville tells the lawyer.
Yeah, if you've got a transcript cite, I think the more clear we are, the better.
Okay. It's at the beginning when Miss Love was there. Hold on one second.
Yep, I remember exactly what he's talking about too. Should have pulled up the transcript, but I'm gonna let the guy who's getting paid lots of money to do this do it. I'm not gonna do it for you, Brian. Get it together. There it says, it sounds like the judge is telling them the judge angle is the way to go. I could be wrong, but I've seen judges do that.
I'm being told page 30, line 5.
Okay, page 30, line 5 is Mr. Copeland talking.
Give me a second. Okay, so I start with page 8.
Page 8, Mr. Copeland's not there. Mr. Copeland doesn't arrive until page 23.
Right, and you asked where the former judge was asking questions that I'd like to
where he gave legally incorrect information to Mr. Copeland.
Okay.
Which is what you put in your motion.
Well, okay, and page 8, though, if you take in consideration, on line 9, the former recused Judge Glanville is telling the lawyer Mr. Copeland. Now, to be fair, I think Ms. Bumpkus, as an advocate or anybody, has got to tell him, meaning her client, he's going to face some pretty significant cross-examination. And then Ms. Bumpkus says yes, or excuse
Was that legally incorrect? I would think, given this defense team that's been accumulated, that's probably accurate, even though it wasn't said to Mr. Copeland.
The judge, though, and the motion is, calling the judge and the prosecutors and disqualifying prosecutors. The judge has stepped out of his role as a judge. What judge tells a lawyer, tell your client, whatever the words are, you make decisions, obviously, but this is how I read it. Tell your client he's going to face significant cross-examination. And you know what else? The judge goes further.
Nah, they're kind of grasping at straws there, Brian.
Him that the client, he's telling Mr. Copeland that the clients are guilty.
Mr. Copeland's not here at this point in time. This is his attorney, Ms. Bumpus.
All right, let me get that for you. It's when the judge is saying, they, meaning the accused, know more about your criminal conduct.
Okay.
But let me find it.
Yep.
Okay, on page 26, Your Honor.
Good morning, Mr. Tesla.
Line 16.
Uh-huh.
Mr. Copeland should be there.
Yes.
I'm just following what the court told me, 23.
Yep.
The court said, so if you, I believe Mr. Copeland, are worried about what the defendants may ask you because they may know your business, but if they ask you about things that you might think you might have some liability with, you can't be prosecuted for any of those. Why?
Well, I think because this whole thing has to do with the fact that there was a 507 immunity order granted.
But he can be prosecuted for this case.
Which is not what the judge is saying there. Okay.
I don't know. I don't know any judge who gives advice like this. Then on page...
Well, if you are, I mean, if the topic of
we need to move along
is to ensure that Mr. Copeland understands what it means that he just got immunity, which he certainly does not seem to at the outset of this meeting, and the nuances of that. I mean, that's a nuanced issue even for lawyers. It might be appropriate in the context of ensuring the client understands what could get him in jail for contempt and what the grant of immunity means, that he would explain to the witness, the potential witness, here's what it means. So, all right, I don't find anything improper about that particular one.
All right, so we're moving on. Next point.
On page 30, it's not the judge now, it's Mr. Copeland speaking.
Here we go.
Page 5, I believe he's speaking about the district attorney, but in front of the judge. You told me before you went to the judge with whatever thing you called, went to him with, and I believe that that's the use immunity order.
Right.
You told me I can't, when I'm asked a question, I can say I don't recall or I don't remember, excuse me, I don't know. You told me that if I plead the fifth, I mean something. Why would I plead the fifth to something I ain't do? And I said that you don't know what I did and what I ain't do, and then you was like something. So to me, telling a person you can say you don't know, nobody should tell a witness you don't know. That's all the state wanted. I don't recall, so they could get in a prior. It's in front of the judge. And then with Mr. Talking about what the judge did or didn't do for cross-examination of Ms. Hilton and Ms. Love, that was Brady, as you said, evidence. Yes, I have it now. But why wasn't I told that?
Yeah, exactly. He had to fight for
I
it.
want to ask questions.
Okay, so
I mean,
Judge Glanville is off the case. That all would go to whether it's appropriate for Judge Glanville to be on this case. That has been taken care of.
My understanding of the law is the motivation for any witness to testify is admissible evidence.
Right, and you can certainly ask Mr. Copeland about that.
And I'd like to ask the judge.
Oh, he wants to get Glanville on the stand.
Line 3, until the trial is over, until all defendants have been, I got these 6 that we have right now. Then there's another 6. Ms. Hilton said, no, there's another 12. The court said there's another 12 or thereabouts that are still outstanding for various forms or another. And they're talking about he has to stay in jail. And I'd like to ask Ms. Hilton, Ms. Love said the same thing, and Judge Glanville. Why would you tell him that when that is not the law? You can't just hold a human being.
All right. So You can certainly ask Mr. Copeland about that.
Okay.
I don't know that.
What about
the
Judge Glanville?
prosecution's motivations are relevant to the issues that the jury is supposed to decide. And with regard to Judge Glanville, again, he is not involved in this case anymore. So I'm definitely not going to permit you to cross-examine Judge Glanville in front of the jury because frankly, it's irrelevant, and he's been recused.
State's
so
up 3-1.
To the extent that, do you have anything else with regard to why it is you ought to be able to have Ms. Love and Ms. Hilton removed from the case?
Yes.
Okay.
So, and just go back to your answer, last question, page 44, line 22, it's Judge Glanville speaking.
Mm-hmm.
And he said, okay, so you testify about some aggravated assault or murder. They can't prosecute you on it because that's what the order said.
Okay,
That's just not true.
I'm sorry. Where are you?
Page
I may be on
44.
44.
Line 22, Judge Glanville
Oh, okay. I'm with you.
speaking.
Yeah.
He said, okay, this is Judge Glanville. So you testify about some aggravated assault or murder.
Okay, so I'm
They can't
actually not
prosecute
with you.
you.
Page 44, line 2?
22.
22. Okay. All right. Gotcha.
Judge Glanville speaking. Okay, so you testify about some aggravated assault or murder. They can't prosecute you on it because that is what it says on the order. And that's not true. They can prosecute him. They can't use his word.
Right.
Okay. All right. I will take all of that into consideration.
That's true.
I don't think that I'm going to make a ruling on this particular motion today. I want to take a full look at all of it in context because I do think we have to consider it in context. But I will note that one down as well.
So let me then answer your question directly. So what's going to happen in my mind's eye is I'm asking all these questions to Mr. Copeland. He's answering however he answers.
What's up, Steph?
I am pointing fingers at the two prosecutors. That mandates that the jurors have to rate their conduct that happened outside the jurors' purview. I am saying that he being Mr. Copeland, was given erroneous legal information. He was encouraged by the holding of hands of Judge Glanville, Miss Love.
He was
and
on
Ms.
their
Hilton,
team, he said.
that they all intimidated, coerced, directed, encouraged, whatever the right word is, Mr. Copeland to do what they wanted him to do. It's in the transcript. We need you to testify, Judge Glanville said. Mr. Copeland will say, I don't know what he was going to say. But yes, I felt that. I felt that they were not going to let me out of jail. I can't then have, nobody should have, then lawyers stand up when the jurors now need to rank what they are doing in the case. Their conduct is at issue. I'm not making them witnesses. I'd rather they stay on, to be quite frank with you. They made themselves witnesses.
Oh, shoot.
The reason is because they injected themselves in such a, my opinion, inappropriate communication with a court and a sworn witness who did not ask any questions. The gentleman was represented by known counsel. He says, and it's in here, I could give you the page, but there's no reason. Take me back to the jail. Judge Glanville said, do you want to talk with your lawyer, me, or the state? Why would a judge say speak with the state and go around the lawyer, even in front of the lawyer? So all of this to me is very at the heart of that gentleman's testimony, his credibility, and it invokes and puts into effect the testimony and credibility of Miss Love, Miss Hilton. I can't ask anyone on the earth. I have a transcript, but I can't ask Mr. Copeland, why did Miss Love tell you, or tell your lawyer, if your lawyer told you, and I understand I have to stay away from attorney-client privilege, but did you ever find out this statement? And if his answer is yes, because Judge Glanville said, remember, Miss Love told you. We just read that. I want to talk about that. And then at some point, I want to ask Miss Love, why would you tell a human being that he's going to just rot, in my words, rot in jail until 26 people are gone, which is not the law?
Mm-hmm. It's a good point.
And Miss Hilton,
he's landing the plane.
That if he lies, and you know he lies, you're not going to charge him. Why?
Okay.
And those promises were not given to us. They were hidden from us. And Judge, this did come out. Your Honor, this did come out. I got it now. I understand that.
Great point.
But if you look back at June 10th, 2024, about 11 o'clock in the morning, not the ex parte hearing, recused Judge Glanville comes on the bench. Please look at the transcript because I'm not verbatim. I understand that Mr. Copeland's going to testify. Mr. Copeland's put on saying, are you going to testify? He said yes, and we rolled into questioning. I don't know how it got away from the prosecution, Miss Love, Miss Hilton, Judge Glanville. By the way, he told us things that are specific on the case. He said in here, I could give you the number, I committed all these crimes. All these
there
crimes
it is.
He's asked about sexual indication for murder. We don't get any of that.
Finally.
So for all those reasons, I'm going to cross-examine Mr. Copeland. I'm going to bring all that out. And the people who are at the heart of that conversation are witnesses as well. They should not have done it. Then they tried to hide it, which I'm bringing out as well. And then just, I don't know how, but by circumstance, fortunately, whatever the right word is, we did get the transcript. If you read the transcript, I asked Judge Glanville for the transcript. He told me it was privileged.
All right, so I think this is rehashing kind of old ground that's not relevant to where we are right now.
I want to bring it all up in front of the jury, though.
Well, we'll get there when we get there.
And that's what we talked about several times, that I did these crimes. Brian Steele, I think it seems like he's just holding on to this until he gets Lil Woody on the stand, because as y'all know, he's already got immunity. He can't stand the state. I don't know if he likes Brian Steele or not, but he wants to get out of there, save face, and not be in jail. So he says, I did these crimes. They go back. The state is going to be in trouble.
But this is not, I cannot call anyone else. You can only go in the mind of Miss Love. Why did she call the meeting? I don't know. Anyone else could answer. No one asked for that meeting. This is my
Why weren't we invited?
And Miss Love stands up here and said, we needed to answer questions because Mr. Copeland asked questions. I don't see that. He's represented by a lawyer. I mean, I don't see that.
Okay, well, thank you. I appreciate it.
Anyway, that's the basis of calling. I heard what you said about Judge Glanville. That's the basis why I want to call Judge Glanville and ask, why did he join the prosecution team? And I believe that then dovetails into Judge Glanville saying wrongly that I was not prepared, wrongly that I was unprofessional. And then he later acknowledges that, but he says, I'm not going to instruct the jury. So the jury's never heard that. And I heard what you said, that you'll instruct the jury, but I'm going to argue that instruction, that the judge has no role in the case except, it's not verbatim, but except to make sure that every party has a fair trial. I'm going to tell the jurors that didn't happen.
Okay, well, we'll see whether that's going to be something that is a permitted argument or not if we get to that.
Okay, but that's...
Can you imagine Judge Glanville getting on the stand and Brian Steele says, former recused Judge Glanville, why did you say we need you to testify? Can you explain? Get him up there, Judge Whitaker. Come on now.
My strong belief that the jurors get to know who the judge was for 18 months.
Mr. Sharp, you look like you want to say something.
Thank you.
Brian was able to land the plane. It was a little bit bumpy there for a minute, but
focus on things that we're likely
I agree.
to discuss.
Okay. And yeah, remember that this is the motion to disqualify Ms. Love and Ms. Hilton.
Right. I would just like to stress one point that, Your Honor, I know that you have joined us and weren't there on June 10th. I think it's important to remember when we're talking about the potential to call the prosecutors as witnesses. My understanding, I know I didn't call an ex parte meeting. My understanding is that Kenneth Copeland did not request an ex parte meeting. My understanding is Caleb Bumpus nor John Melnick, who served as counsel for Kenneth Copeland, did not call for an ex parte meeting. They did not express any concerns. The state
there it is, Varian
called
said
for
it.
an ex parte meeting. And in the beginning of that ex parte meeting, with Judge Glanville explaining the need for the ex parte meeting, the state made statements to Judge Glanville that accused Attorney Melnick of violating his oath and of
They got the emails.
not fulfilling his professional responsibilities and representing Mr. Copeland. They strongly insinuated that myself and Mr. Steele were somehow in cahoots with John Melnick, and were somehow, I guess, obstructing justice, tampering with a witness, intimidating a witness. They presented the judge, and mind you, this is an ex parte meeting where I was not allowed to respond. Mr. Steele was not allowed to respond. Ms. Love stated to the judge, well, Mr. Melnick sent Mr. Steele and Mr. Shard an email, and he may have inadvertently included us.
Here we go.
Possibly by mistake, and was communicating with them that Mr. Copeland would not be testifying. And we don't know what they have going on between them, and I guess we were just lucky to be inadvertently included, CC'd. Judge, I have the email. I believe it's in the record. I can show you the email. The state's not CC'd on the email. It's to the state.
Okay.
So that was a misstatement. Convenient.
Yeah, they do that a lot. Get used to it.
The reality is the state was meeting with Mr. Copeland behind the back of his attorney. The reality is the defense was pristine in their duties in dealing with an attorney and not with a represented individual.
A sworn witness.
And somehow the state in this ex parte meeting where we were not allowed to respond or even to hear the accusations, they suggested that the purpose of this meeting was based on this behavior by defense attorneys and Mr. Melnick, which was completely fabricated and offensive. And again, we weren't there.
Sure.
That's the problem with these ex parte meetings.
All right. Well, I'm going to get a transcript. I have just typed a note to Judge Glanville's court reporter requesting the transcript of the request for the ex parte itself. So I'll find out what it said and I'll share it with everybody.
Okay, well, that's in the beginning of the transcript that you have. It's in the first 6 pages, I believe. In fact, page 3 to 4. Okay. Page 3 to 4, they talk about this email, and we have the email.
Oh, no. I know the email.
Okay.
I'm talking about, I'll get the transcript of the Friday request as well. But yeah, I've seen the email. It's made an exhibit, I think, to the ex parte transcript.
It is.
And just so we're clear, and the reason I say that's important, because again, why are they doing this? What was the purpose of the meeting? Because that couldn't have been the purpose, because their stated purpose was completely inaccurate. Now I'd invite the court, I believe it's in the record, but we can certainly provide a copy of said emails.
It's an exhibit.
Okay, because that's not an accurate rendition, and you know, I'd be happy to answer questions about what happened, but that was not accurate. And these are issues that now the state has injected themselves. As Mr. Steele said, we didn't do this. We didn't do any of this. In fact, we were excluded. We knew nothing about it. And it's improper, and the state initiated all of this, and it's not just what happened in the ex parte meeting, but why did it happen? And ultimately, there's only 2 people, I suspect 1, but we'll say 2, that really know why this meeting was called, because it wasn't called by my understanding Judge Glanville either. It wasn't called by
he's gonna bring up Fanny.
Staff. It was either called by Ms. Love or Ms. Hilton, and we have the right to cross-examine them or examine them about that.
All right, thank you.
What does variant say? The purpose was to coerce a sworn witness.
Yes, Your Honor. Again, responding for the state.
And I want to hear what you have to say. I've got your response. That's your written response. It's pretty thorough. So let's highlight what needs to get highlighted without rehashing everything.
That was my intent.
Not to suggest that you would, but.
Your Honor, I'd like to point to the court, McGlynn, MCGLYNN versus the state, 342 Georgia App, 170 at
he is pushing back too.
173 through 174. In McGlynn, the court notes while Webb dealt specifically with statements made by a trial judge, this court has previously noted that either judicial or prosecutorial intimidation that dissuades a potential defense witness from testifying, or the defense can, under certain circumstances, violate the defendant's right to present a defense. However, such analysis must be undertaken on a case-by-case basis. Here, we note, as did the trial court, that nothing in the record suggests that the statements made by the ADA to the witness were legally inaccurate or misleading. In fact, the ADA's comments seem to have been confirmed by the witness's own attorney, who, unlike the ADA, is charged with acting on the witness's behalf and protecting his rights and interests. As we observed in Terry, the potential for unconstitutional coercion by a government actor diminishes when a defendant's witness has consulted with an independent attorney. That these statements by the ADA were later perceived by the witness as threatening is wholly irrelevant to our consideration of this matter. The court has held that the state is duty bound to inform the witness of the possible consequences of admitting under oath facts that could place the witness in legal jeopardy,
give me 1 second,
including notifying the witness that the criminal law would be enforced to the full extent against those who violate it. And that's the court citing Murray versus the state, 157 Georgia App, 596 at 598. As of course the court has noted, we have included in our response the applicable case law that we believe is most relevant to the court's consideration of the motion to disqualify. In this particular instance, Your Honor, I would assert that the why of any particular proceeding is not a material issue, is not something that is relevant to the juror's determination of the guilt or innocence of either defendant in this case. It's not in any way. It's, if anything, it would be the effect of anything said on the witness themselves, and the witness himself could testify about that. In addition to the fact, as we stated in our brief, there were multiple people there as reflected in the transcript, and there's no reason to, there's no need to resort to an extreme remedy as disqualifying the prosecutors in this case, any more than we would have the right to cross-examine Mr. Steele and Mr. Sharp based on what they may have said to Adrienne Bean or anyone else in this case. So we would ask that the court simply deny the motion for such an extreme step as disqualifying Ms. Hilton and me, and we would base our argument on what we presented in our brief.
Does anybody know what she just said?
You know, something that's tied up with this issue is the fact that, there's been a motion filed with regard to it, and we haven't gotten to it yet, but I think the defense is correct, and I don't think the state opposed the fact that everything after at least the 14th and probably the 12th needs to be redone, and that is all of Mr. Copeland's testimony, virtually all of it.
Did she just say what I think she said? They're gonna rewind Lil Woody's testimony. Please no.
14th and probably the 12th.
Oh my
Needs to be
gosh.
redone, and that is all of Mr. Copeland's testimony, or virtually all of it. And am I correct that the state pretty much concedes, agrees that that's true?
After the point where the motion to recuse was filed by defendant Kendrick.
Okay.
We don't disagree.
All right. So,
Wow.
And that was the 12th.
I believe.
Yeah.
How are they going to undo
So,
all that testimony?
We may be having a really kind of an academic discussion about all of this anyway, because if what the court is going to have to do, and I invite y'all's input on exactly how to instruct the jury about this.
Tell them it's a mistrial.
If we're going to be redoing Mr. Copeland's testimony thus far, we're probably, unless y'all decide you want to stipulate to parts of it, which you certainly can,
Wow.
we're going to be telling the jury to disregard it anyway. And if we're telling them to disregard it, then we don't need to talk about what might or might not have been significant in it, because we don't want them considering it. So y'all keep that in your minds as well. And that may be something we don't get to until tomorrow, but we have to sort of think about that as well. All right. So I am going to take this particular motion under advisement. And I'll get
Ooh.
your ruling quickly.
Okay, so we might have a tie here. So right now the state is up 3-1, but when it comes to getting Hilton and Love off of this trial, she said she's going to take it into consideration. Ooh. That is interesting. Let's keep it going.
Probably tomorrow.
Oh, Rose asked if I'm married. I thought you were asking if Love was married. That's funny.
Mr. Copeland testified hardly at all on the 7th of June 2024, but then did testify
my cousin.
the 10th, 11th,
Right.
and then the 12th is what
Right.
you referred to.
Okay, Ro.
And I understand we'll take up that motion tomorrow, but there was a lot of exculpatory information. I'm not going to agree to strike all that testimony.
It's sculpted.
Okay. Well,
want you to be
what I mean that we'll get to tomorrow is how to, and I'd love for y'all to get together on whether there are any parts of his testimony that occurred before, the testimony that occurred before can stay.
Okay, I misunderstood what
The
you said.
testimony that occurred after the motion was filed, if there are parts of that testimony that y'all can agree to, then that
Oh, good luck with that.
will be great, because it'll save us time and we'll have better contours about what we're dealing with. So I want y'all to get together about that, and we'll think about that probably tomorrow, maybe the next day. I don't know, but not today.
Yeah, and that's a good point. Although Lil Woody's testimony was fun, we got a lot of clips out of it. We got a lot of viral content. Did he really say anything of substance? No. So I get what Brian's saying. He said the testimony was exculpatory. Got to look that word up. But at the same time, that's not really the issue. His testimony, he said, no, what you mean? I can't hear. Ooh, back up. She fied. Other than that, what do we have? The issue is the jury. What did the jury hear from the state? And Lil Woody saying, what? What you mean? And then the defense didn't get a chance to cross-examine. That's the bigger issue than actually keeping Lil Woody's testimony, is how are you going to get the jury to unhear what they already heard?
Okay. But y'all after court today can think about that together with each other. Okay.
The reason I stood
And the
up, though,
alkaline.
Yes.
I just want to make that introduction. The reason I stood up is the following. The state elicited testimony. Now, Mr. Copeland denied it, and they've done it with many witnesses before the Honorable Court took over the case. You've never had to testify in front of Mr. Williams, Mr. Huey, Mr. Kendrick, et al.
Right.
And you're intimidated and that's why you're not testifying.
Mm-hmm.
I would need to show the jury that it's the state, and I have evidence now, and the judge that has been the person to intimidate a witness. So that's another issue when you're resolving this. Can the Judge Glanville, I heard what you said, but can Judge Glanville be a witness? Can the two lawyers representing the state of Georgia be witnesses? I need that in the case.
Okay, let me ask you this, though. Why can't you use the transcript to get that point across? I mean, it's right there in the transcript. What it is that you assert to be intimidation.
Oh, Judge Whitaker, because we need to hear it from him.
Intending to cross-examine or examine Lawyer Hilton and Lawyer Love.
I know you're intending to, but what I'm asking you, and I don't mean to interrupt you, but I want you to answer the question that I asked you, which is why can't you use the transcript to do that?
Because Mr. Copeland can't discuss. Why are you asking these other witnesses this? And what other witnesses, how do you treat other witnesses? There's another witness named Miss Bennett who said basically the same thing. She was intimidated by the state.
Get with it, Judge Whitaker. Come on.
I can't ask Mr. Copeland.
But the issue, as I understand what you're saying to me, is that you want to get before the jury that the state and the court intimidated Mr. Copeland into testifying, essentially. What you say is the intimidation is reflected in the transcript. Ms. Love's motivation for doing it, if she in fact tried to do that, is not the relevant issue.
But I have evidence of other witnesses who were treated not similarly, because I don't have any other evidence that there was some meeting. Okay,
let me help Judge Whitaker out. Basically what he's saying is he can't ask Lil Woody what somebody else said. He can't say, Lil Woody, why did Judge Glanville say we need you to testify? Lil Woody, why did Ms. Hilton say that you wouldn't be prosecuted or that you could lie? Lil Woody's gonna say, huh? What? He can't ask them that. I'm a little confused why Judge Whitaker is confused on this. He needs to hear it from them to have a proper cross-examination, unless he's just allowed to have Lil Woody say why he thinks somebody else said what they said. It doesn't make any sense. It doesn't make any sense.
The judge and the prosecutors, like there was in this, but that the prosecutors are doing the same thing with other witnesses.
Okay.
They are intimidating other witnesses,
right.
and Mr. Copeland can't answer those questions.
Okay, but that you can argue because you will have, look, we see that it happened here. We've already heard that it happened from the mouth of XYZ witness. Imagine it's every witness. I mean, that's the topic of argument. So I think that I'm going to look at all of it again, but I don't think that's a persuasive argument for why they need to.
Oh, come on, Judge Whitaker.
I think the transcript is what you need and what you have, but we'll take that up later, and I will think about that.
All right, so the state is up 3-1-1 right now.
Can I just briefly address something you said earlier? Sure. Well, I did argue with the court that everything after the afternoon of June the 12th is void and needs to be thrown out. Right. I do not, just for purposes of the record, I do not concede that this trial can continue.
I understand.
I just want to make sure.
A couple of motions from
Just want to make sure that's there, because you're asking us to meet tonight to go over what could possibly remain. Well, and I don't know that that's possible. Thank you, Your Honor.
Well, it's possible. I mean, unless I rule today that y'all have a mistrial that is with prejudice, it is certainly possible for y'all to meet tonight.
No. Absolutely. I understand that. We'll follow whatever order that you give, Your Honor.
All right. Thank you. Okay. So the next motion is
we haven't gotten to the bond hearing yet.
Motion for mistrial and objection to mid-trial substitution of trial judge.
It's the big dog, Mr. Harvey.
Quite lengthy and detailed with many subparts. Mr.
Judge,
Harvey, are there things other than what is in the written motion that you want to talk about?
They're calling them YSL ponytail.
It's fine if you stay there and hold the mic. That's fine.
Well, what I want to say is I think our motion was in seriatim. Number one, we joined the motion for mistrial.
Mr. Kendricks?
Yes.
Okay.
So I think that needs to be addressed first.
That's right,
And then
Unagi.
our motion was, in the alternative, if you do not grant that motion, then we have a separate motion, which most of these defendants have opted out of.
Okay.
So I think that would be the appropriate.
Fine with me. I kind of had a note that a lot of those two motions go together and kind of have to be considered together anyway.
Well, when I joined theirs, they didn't join mine. So it's a second step.
That's fine.
Interesting.
All right, so it's fine with me. We'll take up Mr. Kendrick's motion for mistrial first.
All right, we got to hear from Mr. Weinstein.
His motion asserts his motion joined by everybody else except for Mr. Stillwell. Is that right?
No, I joined.
You did join this one. Mr. Kendrick's motion
If we're speaking about Mr. Kendrick's motion,
for mistrial filed July 23rd.
so I am, may I make my stance clear?
Yes.
All right, Judge Whitaker, we need a comfort break. Where's Glanville at? Send her a text, Glanville. We need a comfort break real quick.
Our stance, Mr. Stillwell's stance, is that this trial is completely broken. It's broken.
Facts.
There's error in this trial that would never survive appellate review.
There's coercion.
Illegal ex parte hearings have occurred.
Witness
Our clients'
tampering.
rights have been repeatedly violated. The
Witness
defense
intimidation.
has been mistreated in front of the jury by
Slander.
a partial judge. It's broken.
Bias.
We are also winning this case. We are put in an impossible position right now because our rights have been violated, but we do not wish to move for a mistrial. We are merely pointing out that this case is broken, and I filed a motion about that, and I will get into the reasons when it's my turn. But I am trying to be very careful to make it clear that I am not moving for a mistrial, but I have extreme doubts about the ability for this case to continue, and I am absolutely certain that my client's rights have been violated throughout this process. Of course, Your Honor, I'm just going to put on the record, this is your first day here, so I'm not insinuating anything about your performance here today.
All right.
Thank you.
Oh, look at him showing love.
And, you know, it may or may not survive appellate review if it continues and if there is a conviction. That's not for me to say. Okay, so
Dang, she said it might
Mr.
not survive appellate review.
Kendrick's motion for mistrial, joined by everybody other than Mr. Stillwell, essentially asks for a mistrial with prejudice because the assertion is that this mistrial goaded the defense into it, and under those circumstances, if a mistrial is granted, and those are the actual facts. That
Yeah, we remember he said he didn't want to do it.
Without the ability.
Uh-oh. Hold on, we skipped ahead a little bit. Let's back it up some. This is important.
That to me is not the state saying, yeah, your characterization is right. That is them saying, no, we were not trying to get
This mistrial, but I'm doing it.
Yeah, here we go. So if y'all remember in the motion that we heard from Mr. Weinstein and Yak Gotti, he basically was saying, this is why we have to do a mistrial. We don't want to do it. We don't want to push for a mistrial, but we were forced to or goaded by the state into a mistrial. So that's where we're at right now.
For a mistrial based on the
Let's
state.
rewind a little bit more.
already in their response. Also sort of in this motion and asserted in a lot of the defense motions are what Mr. Kendrick's attorney's word, the defense into making a motion for mistrial because the state thinks they're losing the case and wants to be able to do whatever with. I got the concept right.
Yes, Your Honor.
Okay. All right. So this is also a lengthy and well-briefed, well-written motion. I will hear what you want to add. That's not already in your written motion, if anything.
Thank you, Your Honor. I have nothing to add to that motion.
Okay.
As a lawyer, I feel compelled to speak to it, but I will sit down,
Okay.
given that I have no additional information. I would like to respond if the state does have something to add.
Okay.
I did not see a filed response from the state to our motion. I was served a response, so I'm not quite sure. I'm not quite sure what that's about, Your Honor.
Now, sometimes they get filed, but they don't show up in Odyssey for a couple of days.
I wish we had access to Odyssey.
Because y'all have been good about emailing the court when you file. I haven't actually checked Odyssey to see whether it's in there or not, but I would imagine that if the state served everybody with a response, they also filed it. If not, they need to. Okay, so that is a part of this motion. And another part of the motion is, well, I think you say as well that we'll need to redo the from 612 on.
She's playing it fair.
That's a part of this motion.
That is a part of this motion, Your Honor, yes, that there is a requirement that everything after 612 is void.
Okay.
And in that motion, we argue what I stated earlier, that I don't believe it's possible to erase that information from the jury.
Okay.
Also, I'm happy to take any questions you may have.
Okay, I appreciate it. All right, so.
And that's when he said in the motion, you can't, if you tell somebody don't think about flying elephants, they're going to think about Dumbo, right? Which is true. Somebody tells you not to think about something, you're going to think about it.
Yeah, so there are a lot of different grounds in here. There's the state sought it.
You can get access to
because
Odyssey.
They wanted the defense to ask for a mistrial so they could get a mistrial and try the case over again.
Oh, I'm signing up right now.
Substantively speaking, the ex parte was a critical stage at which the defendants were excluded. And then the concept of, which we've kind of brushed over somewhat, that Judge Glanville's comments in the ex parte itself amounted to unconstitutional coercion of Mr. Copeland to testify.
Those are exactly my arguments. That's correct, Your Honor.
Okay.
There's three main issues, three main arguments that I put forward in that motion. The only thing that I can think of that maybe I did not sufficiently highlight is just the tremendous experience of the prosecutors and skill of the prosecutors in the state as both, in this case, as both attorneys and prosecutors. So I cannot believe that they would not have asked for this ex parte, conducted the ex parte in the fashion that they did it, unless they knew that they would be forcing us into a position to request a mistrial. As Mr. Shart has said, we are winning this case. The state's witnesses have not testified the way that I imagine they expected them to testify. And I do not believe that they should be allowed a do-over in this case, Your Honor.
All right.
But I'm not going to repeat what's already in front of you. Okay, thank you. Again, if you have questions, I'm happy to answer any.
And then also sort of in this
I'm
motion,
doing it right now, Barry.
asserted in a lot of the defense motions are what we again touched on, that Brady material arose from this ex parte, and y'all have it now, so it's not a Brady violation anymore.
And
to the extent there was.
And that's not a real requirement
Okay.
in order to grant our motion, Your Honor.
All right. I just wanted to make sure I covered that as well. Okay. Does the state want to be heard with regard to anything not already in their response?
Yes, Your Honor.
Okay.
Just based on Defendant Kendrick's representations to the court and others that they're winning, and therefore we goaded them. If they're winning, then let's just keep it rolling, because the state vehemently objects to a mistrial.
Okay.
And
dang, okay.
I am unclear how we are arriving at the conclusion that the
shots
state,
fired.
in conducting something according to the rationale presented to the court by the defendant so far, that the state never intended that they find out about, in an effort to cause them to do something. I don't know how those two can be squared with one another. So we would ask that the court deny.
There's that attitude we love.
For a mistrial based on the state, based on anything. I'd point out that this is not the first or the second or the third motion for mistrial. The state has objected every step of the way. We continue to object to a mistrial. Again, if they feel they're winning, let's keep it rolling. And we would ask that the court just deny it. Of course, the court is aware that the issue here is not whether anyone acted improperly, but what objective the prosecutor is trying to achieve. It does not make sense to assert on the one hand that we want you to not ever learn about it, and on the other that we are intending that you be goaded into an act by our doing it. Okay. So thank you.
There are issues here as to whether people acted improperly. Perhaps that does not go to the goading, but I don't want to, it's clear in my motion that we are arguing that there was improper conduct by both the state and the judge that violated Mr. Kendrick's rights. He has been locked up in Rice Street for 22 months. I have done everything that I can to move this trial along. I filed a motion, I believe at the end of March or early April, to try to get this trial moving at a more deliberate pace. That motion was essentially denied. I have no interest in retrying this case, Your Honor. And we are winning, I think, by any measure. So I'm asking for this mistrial, but I'm doing it because I have absolutely no choice but to do that, Your Honor.
All right.
Man, the shots back and forth are crazy.
I think this was Mr. Nichols' reply to the state's response. So I don't know if it was with regard just to Mr. Nichols' own motion for mistrial or also Mr. Kendrick's motion for mistrial, but I think the argument is applicable to Mr. Kendrick's as well, so I'm going to address it right now. Mr. Nichols argues that the state says that the defense's characterization is a mischaracterization of what happened in the ex parte, but does not offer their own characterization, and therefore they essentially aren't opposing it. And I should just take as fact everything that the defense said. And I do find that the prosecution did, in fact, oppose the characterization made by the defense and posit their own characterization. In their response, they say, quote, the hearing in chambers was proper, unquote, and then quote case law.
That's not.
So that to me is not the state saying, yeah, your characterization is right. That is them saying, no, we were not trying to get a mistrial here. We didn't do anything improper. So with regard to that issue, I'm not finding with Mr. Nichols.
Interesting.
Now, I am going to, in the context of taking under advisement the other motion that we talked about before, take under advisement the concept of whether what occurred in chambers was coercive, and if so, was coercive to the extent that under the cases like, I think, Wynn and Webb, it requires a mistrial. Because I think the concept generally was before Judge Krause, but not in the kind of detail that it is right now. So I do think that that is something that I can take into consideration and will take into consideration. And y'all both briefed it, and so I'll get the ruling to you. As with regard to the propriety of the ex parte itself,
okay, here we go.
Already talked about. I don't think that was the actual basis of Judge Krause's order on the recusal. So I will endeavor to make a substantive ruling on that as well. So that's another one that I'll probably give you my ruling tomorrow.
Okay, so we could have a mistrial tomorrow because we're going to find out two things tomorrow is what Judge Whitaker is saying. We're going to find out if Love and Hilton are still going to be on the trial, and we're going to find out are there any grounds for a mistrial? Let's see.
So, making myself a note. All right, now to
always, Amy.
Mr. Nichols' motion for mistrial, which, in addition to everything else that's in Mr. Kendrick's, essentially says that there are reasons why the mid-trial substitution of another judge makes this impossible. And Mr. Harvey, I know.
I apologize. Can I interrupt you again?
Yes.
Thank you. I do that with, a smile and a request for permission.
Okay.
Again, I think there are several other mistrials with prejudice that have not been heard by you, and that would include Mr. Williams filed on July 10th of 2024, entitled in part, Motion for Mistrial Based Upon Judicial and Prosecutorial Misconduct and thus bar
Get him, Harvey.
retrial. Mr. Shart, on behalf of Mr. Jackson, also has a mistrial with prejudice pending that I don't believe the court has heard. And again, I think in seriatim, if you decide on all of those, then I'll come behind these brilliant lawyers.
All right, I appreciate it. So with regard to Mr. Williams earlier, prior to the, July 9th, honestly, I don't know that I saw a motion to recuse filed July 9th, but when we talked about all of the pending motions before, there was the July 10th motion for a fair trial and for mistrial and prosecutorial and judicial misconduct. That's one of the first motions I took up today. Is there another one? Yeah. Well, I did. That was one of the first ones. Is there another one other than that?
I don't think there is.
Yes.
Mr. Williams is not asking for a mistrial. If you grant a mistrial, then that would be over objection, and that if you grant, I joined in the goading. See, I think it's a two-step process. You grant a mistrial or deny a mistrial. If you grant a mistrial, then there has to be a conversation about a plea and bar. So I'm joining. If you grant it, it'll be over objection, then I'm going to file a plea and bar. So I was just upfront with the court. So
but with regard to anything, is there any motion for mistrial filed by you on behalf of your client other than the kind of, not really omnibus, but multifaceted motion you filed July 10th that was for a fair trial to get all the ex partes for a mistrial based on prosecutorial and judicial misconduct?
On Friday, July 27th, I filed a response to the state's you called it a gag order. And in that, the second part, I also filed an adoption that if you declare a mistrial, it will be over objection. And then I will be raising a plea and bar because it would be the only reason to declare a mistrial is because the defense was goaded into it. So that is it. So.
Okay. All right. So, Mr. Harvey, I don't think Mr. Williams has another one. And then
I don't think so either.
Mr. Shart, on behalf of Mr. Stillwell.
July 23rd at 3:07 p.m. a motion for fair and constitutional trial. I believe I have a lot to say.
Yeah.
And I believe I'm similarly situated to Mr. Steele in many ways regarding that, because I do believe we're being goaded into moving for a mistrial. I do believe that the case law supports that conclusion. I do believe that so much in this case has happened that has broken the case. I believe, and I'd
Grab
love
the
to
mic, Max.
argue all of that, but I am not specifically asking for a mistrial unless jeopardy attaches.
Okay.
And so that's where I'm at. I'm happy to argue that. I'm happy.
And Adams is he's sitting there at the back. Right here.
Or Mr. Steele.
Okay. Give me just a second.
All right, we'll see. Oh, it looks like they're going to take a break in a minute, so we might have to jump ahead. It's nice because we're a little bit behind, so we're going to jump ahead here in a minute. So y'all stay with me.
Sure. You know what? I need to find the motion that was just referenced by Mr. Shart. Anyway, why don't we've been going for a couple of hours. Why don't we take a 5 to 10 minute.
This is our first break, y'all. What do you think so far? Woo! This has been crazy. All right, so we have a few cases where the state has won, a few cases where the state took a little bit of an L and they're waiting. And it's actually, I need to update the score. I should have had a score right now. So the state is up right now. They're up 3-2-1, which is crazy because we have two huge pieces of this trial that we're going to be hearing about tomorrow. According to what Judge Whitaker said, she's going to make a decision on whether Love and Hilton should stay on and also whether there's going to be a mistrial. If she's got to think about it, I don't know. Y'all let me know what you think in the chat. I'll be pulling some of y'all's comments up as we go throughout the stream. But thankfully, we are a little bit behind, so we can catch up here because I think they're back. So let's go ahead and fast forward a little bit and get back into it. Lauren Robinson says a lot to take in. Hey, yo. Variant says motions upon motions. Yeah, we're going crazy. Here we go. She's back.
I wanted to address to the audience is that there's been kind of a lot of up and down and back and forth and in and out, and that is distracting. So I know there may be times when you need to step out for a particular reason, and that is fine. But let's try to minimize that, because if it gets too distracting, I'm going to have to ask you to step out until all your business is taken care of. Okay. So if you got to go out, but then it can't be a up and down every 5 minutes thing.
Yep. Tell them, get it together, Judge Whitaker. Barrett says, I have a feeling that some reason she put up all those motions
Mr.
first,
Shart,
or she agreed with the state.
Saw
She's
your
probably
motion for a
going
fair
through
trial, and the reason I didn't register it as a motion for mistrial is because it's essentially not. It's saying if you grant a mistrial with prejudice, we're in on that. But otherwise, we'd like to, even though we think this trial has been a disaster, we would like to keep going because we think we're winning. So you asked that it be a constitutionally fair trial, and I guarantee to everybody, to the extent that is within my control, I want for everybody here to have a fair trial. Under the Constitution
Me
of
too.
the state of Georgia, the United States, and the laws of our state. Okay, that is why I am here as a judge, to make sure that that happens. So to that extent, it's granted.
I appreciate that. I guess my concern is that all this is not under your control because.
All right.
And I can hear you fine, but I don't know whether my co-reporter can or not. You can either come up or you can pick up your mic if you're just a long way away.
I guess my concern is that and I have no doubt that you will do everything in your powers. I just don't know if at this point, if it's within your control to ensure that we receive a constitutionally appropriate and fair trial at this point.
It's
based
tough,
on what's
man.
happened
Tell him, Max.
previously. And, you know, I do have cases regarding the concept of goading.
Okay.
I don't, but I'm
Here
trying
you
not
go,
to
Barry.
step out of turn. I know that I am stepping out of turn a lot this morning, but I'm trying to not step out of turn. If you would like those cases.
Yeah, I'm happy to take into consideration anything that y'all want to offer that is on point.
Go.
Here comes your case cites variant. Get ready.
May I approach?
Yes. Can't really get to me, but you can get to my staff who can hand it to me. Thank you. Oh, yeah. I've seen web cited, and I'll take a look at Jackson and Wilson.
Oh, did I not give you Anderson?
No.
Oh, I'm sorry.
Thank you.
I might need a comfort break here in a minute.
Okay.
And Your Honor, I believe that those cases stand for the general proposition combined. Each of them are a little factually different,
Okay.
but they stand for the proposition that the trier of fact can consider certain factors. Of course, the difficulty in determining if someone's goaded someone else comes down to intent. Typically a district attorney or a prosecutor is not going to take the stand and say, I intentionally goaded someone. So you look at objective facts, and these cases stand for the proposition that you look at how basic the rule that was violated is, the experience of the prosecutor. In this particular case, you know, this is a big county. The prosecutors involved in this case
It is a huge
are
county.
a chief deputy with the district attorney's office and a deputy with the district attorney's office are the two prosecutors that were involved in the ex parte meeting. You look at the evidence of the case, and I know that this is another area where you're hamstrung a bit because you haven't been sitting to hear the evidence. But I concur that the whole purpose of Mr. Copeland taking the stand was to impeach him. Mr. Copeland's testimony
Max is cooking today.
was not, well, at the time of this ex parte hearing, it's our stance that he was pleading the fifth, and the state was in a position that their key witness, and without him, the alleged murder of Donovan Thomas, without his past statements, goes away. And they were in a situation where their key witness was not taking a stand and was not going to allow himself to be impeached with prior statements. And our stance is that they panicked and they needed a mistrial. The trial was not going well. The previous witnesses that have testified, it's been again, I know you haven't been here, but you know, we've had witnesses testify. I don't remember anything that happened in 2013. It's just been a parade of impeachment by inconsistent statements and contradictions. So, and that's
He
another
told him he was
factor
going to
that
lie.
those cases look at is the how the trial's gone so far and the motivations for goading a mistrial. So I believe that those cases provide some insight and some guidance for the court to consider certain factors when we get to that goading question. And that's why I wanted to bring those to the court's attention.
All right, I appreciate
Exactly,
it.
Variant. Exactly.
All right, so Mr. Harvey, you're up. I don't think there are any other motions for mistrial.
And I gotta read it. I hate to interrupt. I gotta read this comment because this is exactly right. Variant said what he told them Monday, Tuesday, Wednesday, Thursday, and Friday morning that he was pleading the fifth. Melnick told them that he was going to plead the fifth. Another reason for mistrial because the state and judge knew that, and that's what Mr. Shart is saying. He said they were just setting him up for impeachment this entire time.
Yours that we have not discussed.
They'll bring it up.
And I am going to address a few of your issues really, well, I guess one I'm definitely going to address before you start your presentation, and that is that you assert in your motion that this court, meaning me taking over this case, has indicated it does not intend on familiarizing itself with the trial proceedings, and I have no idea where you got that from because...
All right, we talked about this when we made a video on it. If y'all remember, I said Mr. Harvey's motion is probably the one that Judge Whitaker is going to take the most personally because he took direct shots at her. I don't think he meant any offense to it, but he said, hey, Judge, listen, there's so much that's happened this entire trial. There's no way, one, you can undo what the jury heard, and you can go back and have the full understanding of everything that took place during this trial. Now, I knew she was going to take offense to this, and y'all can already hear in her tone. She's a little bit like, hey, man, what is this about?
Because I
Here we go.
certainly never said that.
When we were here last week,
yeah,
and I don't have a transcript of that, and if I've misinterpreted what you said, and perhaps it was in the context of you saying, I'm not going to revisit certain motions, or I'm not going to go back to hear those. That was in the context that I meant it. And I said it for a specific reason, because some of the motions, as I allege in our motion, Judge Glanville said, well, you know, I'm going to deny your motion, for example, for a severance, for a 105 instruction at this point. But that does not mean we're not going to get to a point where I would consider that and grant it. So I meant that in the context of you understanding, this court, understanding the cumulative nature of what has happened and how it would factor into your particular decision at the next point in trial.
That makes a little more sense.
I knew she was.
I absolutely intend to familiarize myself with what has gone on in this trial prior to me getting involved in it. I've already begun to. Judge Glanville's court reporter is beginning the somewhat arduous task of transcribing everything that hasn't been transcribed yet and giving that to me, you know, as soon as she finishes it. You all have, some of you have already pointed out, you know, particular things that while not the official transcript, I can review on YouTube, and I've done that to the extent it is.
Shout out to YouTube.
To these motions. And I also believe that with the very capable defense attorneys in this case, that you all will be able to elucidate for me anything that I might not have been here present for at the point in time when you make a motion that to any extent requires considering the cumulative nature of anything. Okay?
Well, okay, yes, and okay, no. Okay, yes, I understand that the court
got some
is going
pushback
to make what I think to be an impossible effort to catch up to where we are at this particular point after.
That's a fair point.
9 months or thereabouts, hundreds of witnesses. I appreciate the court's effort, and I understand the genuineness of the court's statements that I'm going to do it. But you know what? I just don't think it's possible. And that is the gravamen, that's the base of what we contend should be a motion for mistrial qua mistrial. I have joined in we've been goaded into it, but now the second layer of that is I am going to stand here. My team is going to stand here. Everybody in this courtroom is going to stand here and look at you and say, Judge, the state, I want a directed verdict of acquittal. The state has not met their burden. I believe you have to be entirely conversant with the record, with the way witnesses have testified, their demeanor, their voice,
he makes a great
their
point.
actions, all of which may or may not be caught on YouTube. And there are a plethora of cases. There are many cases that say, you know, just reading a dry transcript is insufficient. Every court from the U.S. Supreme Court down has said you can't necessarily make those kinds of judgments based upon a dry transcript. And I believe that to be true. There's a world of difference, and you know this. Every practicing lawyer knows this, that you cannot get the feel of a lawyer. You cannot get the context. You cannot get the understanding of a witness unless you're there to view that witness. So I start from the premise that no matter how hardworking you may be, and I think you're
what's that wet transcript,
Judge, I think that you will make every effort, but I think that it is impossible for when we get up and make our motions for directed verdict that you can assess the now going into the 9th month of trial testimony. That's essentially basis number one.
Okay.
That's a great point. Excellent point.
More importantly, I think that should you erroneously deny our motions for directed verdict, that you then would be in a position to sit on our motions for new trial. And that's the so-called 13th juror. We have put that in our response, and it is
it's realistic.
Without question. We have our courts, the federal courts, all say that there is a distinction between whether there is sufficient evidence to go forward, which is the standard on a motion for directed verdict, and a 13th juror motion for new trial. You can find, you know, I denied your motion for directed verdict, but you know what? I just don't think that this was either a fair trial or a trial in which, based upon what I have seen, what I observed, that should stand, and I'm going to grant it. I mean, it's entirely in your discretion. And that discretion is unreviewable, really, by the appellate courts. And they have all said, as we said and quoted in Wilkerson, that the discretion, the trial court must consider some of the things that she cannot when assessing the legal sufficiency of the evidence, including any conflicts in the evidence, the credibility of the witnesses, the weight of the evidence, meaning that the trial judge may grant a new trial on the general grounds, even when the evidence is legally sufficient to sustain a conviction. So I know that we're going to stand here and make a motion for directed verdict, that God forbid, if any of these defendants are convicted, we will come back to you and say, Judge, motion for new trial, sit as the 13th juror. Don't think you can possibly catch up to that extent.
It's true.
Do I think that
He's
based
right.
upon the cumulative nature of Judge Glanville's saying, I heard you when you want a severance. I'm denying it now, but it may come to the point later that I'm going to grant it. So 3 reasons that nobody else has argued to you, essentially, for a motion for mistrial or a severance as to Mr. Nichols. 1, the motion for directed verdict. 2, the 13th juror. 3, the continuing nature of the motions to sever in for a Rule 105 instruction, a limiting instruction, which the court said, I'm probably going to give that at the end of the
Harvey's up there
trial,
cooking. He's killing it
but I don't
right
think
now.
it's necessary to give it now. So,
Okay.
And if I had to be honest, I think the biggest reason that nobody else got on this one with him is because they didn't want to offend the judge. Let's be honest. As soon as I saw it, just being a layman, just reading it with a little bit of common sense, I said, yeah, I could see how the judge would take this personally. As y'all could see, she brought up her objections to Harvey, saying, hey man, I'm going to do my job. He said, listen, I'm not saying you're not going to do your job. What I'm saying is this is going to take a lot of time, an unreasonable amount of time for you to catch up and understand the weight of what's been going on in this trial. So some of the other defense attorneys probably said, we see what you're doing, Harvey, but we're going to let you handle this one on your own because we want to try and keep our record clean a little bit.
I understand.
And I think he's the right messenger for this too.
And
so
I
smart,
don't really need to
another
hear from
smart
the
play
state
by
on
the
this one. With regard
defense.
to the directed verdict issue, the standard, as we all know, is essentially an any evidence standard. It is entirely possible that just on what gets presented going forward, I will be able to rule on the motion for directed verdict, assuming we get there. But if not, I can and will ask for specifics from the state as to what the facts are supporting each count of this indictment. And it is not for directed verdict whether I'm convinced, it's whether there is any evidence from which a jury might be convinced. And so we'll take that up when we get to it, but I don't think that the fact that I'm coming in mid-trial is a basis to grant
Not even mid-trial.
a mistrial in this case. With regard to the 13th juror, I understand that's a different standard. There are times, it's not routine, but it happens when a different judge from the trial judge considers the motion for new trial and considers the 13th juror issue. And the appellate courts have recognized that it is a somewhat less deferential standard when they're looking at it on review, when it is a different judge than the trial judge. So, if and when we get there, I will consider whether anything ought to be granted as a 13th juror, if y'all ask me that. And if I deny it, then the appellate courts can consider it. But that is not anything unprecedented. It happens all the time that one judge does the entirety of a trial and then another judge considers the 13th juror issue. So that is also not a basis
Yes,
on
they do.
which to grant a mistrial. And with regard to the severance issue and the cumulative nature of that, I'm going to rely on you to point out to me everything ought to be taken into consideration
So
if
is
and
it
when
denied?
you make that motion again. With regard to a 105 limiting instruction, I am happy to consider anything that you all think might be appropriate to give right now. Okay, so I invite y'all to submit something. Okay.
So did she deny it or?
to make sure that my motions were also based on the underpinning constitutional rights, both federal and state. And I don't want the appellate court to say, hey, she didn't say anything about that, but I want to make sure that those bases are preserved although I disagree strongly with your ruling, I'm still here.
All right, understood, and it is so noted, and obviously it's to whatever it is that you have, any of y'all have set forth in your various motions. All right. All right.
So we're going to give the state points on that one. Y'all let me know what you think.
Sort of agreed that we need to redo
State's up.
everything that happened post recusal motion on June 12th, and the
State is up right
details
now.
and logistics of that we'll take up probably tomorrow. But that motion itself is granted. All right.
Wait, which motion was granted?
But that motion itself, post recusal motion on June 12th, and the details and logistics of that we'll take up probably tomorrow. But that motion itself is granted. All right. A lot of what comes next is evidentially specific. And before we get to that, I know that there are some outstanding bond motions. So Mr. Steele, on behalf of Mr. Williams, has filed a motion for bond reconsideration, but Mr. Steele, you essentially go back and argue anew all of the factors that whichever, I don't even know who took up the bond to begin with, but another court has already considered all of those, the Ayala factors. And you don't present changed circumstances. You just
me too,
essentially
Barry.
say this call was wrong to begin with, and you should do it over. And I am not going to reconsider any bond issues that have already been considered and ruled upon by another court absent legitimate changed circumstances. So that.
Oh, no. Bond just got denied. Nobody is getting bond. Dang. So it's looking like Judge Whitaker is going to move forward with this trial because it's looking like the mistrial is a little bit shaky. Sounds like that got denied. When it comes to bond, she said somebody else already heard that. We're not going to go over bond again. Y'all are stuck. Wow. Yeah, Lil Woody is over there dancing in the streets right now. Dang.
Motion is denied.
Can I address the court?
Do you have changed circumstances? So, okay, go ahead. There weren't any in your motion.
Exactly. Time served.
Mr.
Wow.
Williams has been in custody since the 9th day of May of 2022.
There you go.
This is in my motion. Or it should be in my motion. He has sat through unnecessary jury selection for months, bringing in over 2,000 people when the jurors were chosen from the first 511.
Crazy.
That should not be on him. This is excess. He's now sat here for a month while the antics of Judge Glanville and Lawyer Love and Lawyer Hilton cause him to just wander and squalor in a jail.
Come on.
The case is, God forbid there's a conviction, going to be reversed potentially because these are serious issues, and I've raised them. I've put them to the court. There are issues of confrontation clause violations, prosecutorial misconduct, judicial misconduct, not being present at a critical stage of proceedings. There is no reason to believe that Mr. Williams is fleeing. He would be crazy because if he flees, the case goes on because it's mid-trial and he waives his appellate rights. He has the strongest ties to the community and the backing of wonderful people, both near and far, who are willing to come. Those are my changed circumstances.
All right. Thank you. I do not, they are changed circumstances from, yes, things happened after the bond was decided to begin with. I don't know how I would have decided the bond originally. That's not before me. Those are not the kind of changed circumstances that speak to the IALA factors, and so I'm not going to reconsider the bond.
Well, let me ask one more then.
Wow.
There is a judge who joined the prosecution team. He said, we need a witness's testimony. He encouraged the witness, more than encouraged, to testify against Mr. Williams. I think that should
This is crazy.
come anew to the
All
court.
right. Well, that may or may not be a substantive error in these trial proceedings. I've got that under advisement right now, but
that is so
also would not
sad.
be an IALA type change circumstance. So I appreciate you presenting this to me, but I'm not going to reconsider bond.
Even though potentially it was not done by a fair tribunal.
I don't, all right. There is nothing, and I'll make a determination.
And I get what, I'll let her
with
finish and
regard
then
to
I'll
that
give my
substantively,
synopsis
but I will
of
note
this.
that Judge Krause, who had a lot of these issues before her in the motion to recuse, her finding, while I think dicta, was that there was nothing improper. She said, you know, maybe I'd have done it differently, but that there was nothing improper substantively with what occurred. So at this point, we don't have, and the basis of her recusal was not that Judge Glanville is biased. It was that he engaged too vociferously in setting forth facts and information when he denied the motion to recuse. And that was not what the rules require. And so recusal was necessary, but she even, I think, went on to say, but even with that, I don't, you know, I think he could have continued on unbiased. It's dicta, but right now, that is your position in the litigation. It's not a factual finding. It's substantively before me. And if that is the case, then there will be a different ruling made that will impact this trial, that may result in a mistrial, that may result in a mistrial with prejudice, but that would not impact a reconsideration of bond. Now, if there's a mistrial without prejudice, then bond maybe could be considered then. That might be a changed circumstance, but right now we don't have that.
Yeah, and again, we got to give it to Judge Whitaker here. She makes a great point. This bond was decided long before this ex parte meeting took place and any error they want to point to in the trial. So it's not really a change of circumstance. What was decided by the previous court still stands, just like the jury selection, just like everything that took place before, what are they saying, June 12th, June 10th. So I mean, she's right. Unfortunately, it's a shame because we're not really going to know the weight of all that was impacted by what Miss Love and Miss Hilton and Judge Glanville had going on, because clearly they did have something going on. It's a shame for these guys sitting in jail.
Then I'd like you to address just one last thing then. Judge and district attorneys come out after the ex parte hearing and not a syllable about Brady evidence.
What's up,
It all
CG?
should have been spilled right then. That's an ongoing concern. So my point is, you have the same judge denying bond, the same judge hiding Brady evidence. So I'd like you to consider that.
All right. Thank you. I understand. It's
Wow.
not an appropriate consideration, but I understand what you mean. All right. Mr. Huey has a motion for reconsideration of bond with asserted changed circumstances of the ex parte being a critical part of the trial that he was excluded from, and having been held longer than he otherwise would have because of the delay resulting from that. Do you have anything to add to that, Mr. Matthews?
Yes, Your Honor. Good day to this honorable court. Carrington Matthews for Mr. Marquavius Huey. I cite
Shout out to
for
Mr.
the court
Matthews.
Wimbush versus the state, 345 Georgia App 54, which is cited in my motion. When a court has previously heard a motion for bond, its ruling is not subject to change unless the court finds that the movement has presented new information, testimony, or evidence that indicates a change in circumstances. Wimbush, when it talks about new information, new testimony, or evidence that indicates a change in circumstances, I would like for the court to consider that the change in circumstances as it relates to this particular proceeding is that when the court denied the bond to Mr. Huey back in 2022, it determined that he did not meet the Ayala factors. This same court, in making that determination in 2022, the change in circumstances, the new information, the new evidence is that that same court that denied the bond in 22, that court indicated in or on June 10th, it had a meeting that this court has heard over and over again now, right, with a sworn witness, right? And in the transcript, Your Honor, the court that denied the bond to Mr. Huey then, that court engaged in conduct which I believe influenced the witness, caused that witness to reconsider his position that he was not going to testify, talking about Copeland, caused that witness to, rather than say, I'll sit in jail, co-signed on the state of Georgia's recitation that, no, Mr. Copeland, you will sit in jail until every single defendant on this indictment is tried. So what I'm asking the court to do is look at what is the change in circumstance here. The change in circumstances, we want Mr. Huey. He wants an unbiased, a neutral referee to decide whether or not he is a good candidate for bond. I would assert to this court that that has been clouded because a neutral judge, a neutral referee would not have engaged in the conduct on June 10th, which essentially is why he has been recused. So I'm asking the court to say, hey, look, there has been new information, because that was not information that existed when the court decided that Mr. Huey was not a good bond candidate. That was not evidence.
It's a tough argument.
When the court decided that he was not a good candidate. And we're looking at a judgment call here. The court has to be comfortable. The court has to be confident that when a request for bond is made, that the candidate, based upon the change in circumstances, would be a good candidate for a bond. Now, Mr. Huey has been in custody since December 14th, 2021. It's a long time. Now, Judge, we have been out of court, out of session for over a month and some change and still counting. That delay, Your Honor, is a change in circumstance for Mr. Huey. He is on 23-1 at the Fulton County Jail. He's on lockup for 23 hours out of the day. 1 hour out. We don't have to go over and over what the conditions are at the Fulton County Jail. We know what they are. The news media shows us what they are. He tells me what they are. When I go visit him, I see what they are. So what I'm asking the court to do here is look at those change in circumstances. Now, here's another factor. How much, Your Honor, does it cost the taxpayers of Fulton County, Georgia, and the state of Georgia?
Mr. Matthews, that is not an appropriate consideration for bond.
Yes, it is.
Understood, Your Honor. I'm asking
we want our money back.
Look at
Come on now.
The resources that are required to have Mr. Huey here every day. That's all I'm asking the court to look at.
Consideration for bond. All right.
So essentially,
yes,
Your Honor, I'm asking the court
Objection.
to look at the change in circumstances that I have cited in my bond motion. I'm asking the court to take that into consideration, that the decision to deny the bond for Mr. Huey in 22 was made by the recused court. And the change in circumstances that I am alleging were done by the recused court.
All right.
Based on judgment calls.
Okay.
So, Judge, I'm asking the court to set a reasonable bond with conditions. Here's what I'm asking the court to do. Put a number on the bond. I'm asking the court for a $50,000 bond. I'm asking the court that Mr. Huey be required
It's not gonna happen.
to live at a certain residence here in Fulton County, that he be required to have 24-hour house arrest on a monitor, right? He be required to only come to court and only meet with his attorney for the duration or the rest of the proceedings of this trial, if it gets that far. Obviously, to have no contact with any other co-defendants in the case, and for any other reasonable conditions that this court believe would be meet and proper based upon our request. We believe in 2022 that the Ayala factors were met. The court has indicated, obviously, that the other court made that decision, and then this court wants to hear about the change in circumstances. I think I've efficiently been able to lay those out in our motion, support it with proper case law, and also I would, just for the record, I would address the case that I cited with respect to the ex parte meeting, and that's Scudder versus the state.
I appreciate him showing that he's going to fight for his client, but this man, he's not going to get it. She already said, I'm not considering any other bond, so y'all just chill out for a minute. Is there going to be a mistrial? Is that why she's telling them, hey, y'all just relax? Even though she makes some good points, I don't know. Y'all let me know what you think.
98 Georgia 438, a 2016 case.
What was that site? Is it in your motion?
It was in my motion, Your Honor.
Okay.
And the Scudder court determined that a criminal defendant has the right to be present and to see and hear all critical parts of his trial.
Okay.
So forth and so on.
That's with regard to that substantive issue.
Yes, Your Honor.
Okay.
Which we are alleging is a change
Okay.
in circumstances. A change brought about by the court and not by Mr. Huey. And we believe that that month-and-a-half delay where he's had to sit in the jail, we're asking the court to not only be a court of law, but to be a court of equity, which this court is. And we believe that equity and fairness dictate that a reasonable bond be set in this case. Otherwise, any other change in circumstances that are not brought about by Mr. Huey has to suffer the consequence. And that's what he's doing. He's suffering the consequence, Your Honor.
Okay.
Respectfully.
Thank you.
Thank you, Judge.
All right. So that the record is clear, the basis for the recusal of Judge Glanville was not that he is biased, was not that the ex parte itself was improper. It was that Judge Glanville engaged in an exposition on the facts in making his rulings on the motions to recuse. I understand the argument that the court who undertook the original bond consideration in the defense's view has become biased, but that in the same way that I said to Mr. Steele with regard to Mr. Williams, if I substantively end up determining that, then it may be appropriate at that time to take up bond again. Right now, it is not. And it is unfortunate that this case has lasted as long as it has. It is unfortunate that there have been delays in the case, but those do not, in this court's mind, amount to the kind of changed circumstances that make it appropriate to reconsider bonds. I am not going to reconsider or grant bond in Mr. Huey's case either. Mr. Kendrick also has a motion to reconsider bond.
So that was denied.
Changed circumstances that essentially this case has taken way too long, which I don't necessarily disagree with, but
I would ask you for Mr. Kendrick's bond motion, if you could defer ruling on that until after you rule on the mistrial.
all right, I will do that. I
Thank
think
you.
that would be more appropriate. Thank you.
Oh, wow. So Mr. Weinstein said, hey, I don't want to file this again. Just hold on to it for a couple days and we'll wait until a later date. Sheesh, man. The state is up 5-2 right now.
Okay. So the next thing I think that it would be appropriate for us to begin to undertake is some of the specific evidentiary motions. Mr. Stillwell has a motion it's entitled for reconsideration regarding certain hearsay statements, but given that we've all acknowledged we're redoing Mr. Copeland's testimony, it's not even really reconsideration. It's consider
That's a good point too.
Anew as we go forward. So I'll hear you on that.
Thank you, Your Honor. Before I get started, could I hand over a case? It's actually the Scudder case that Mr. Matthews
Sure.
referred to. And the reason I'm giving you this case, when you consider some of the issues that you said you're going to consider tonight, I never really, and I understand, I'm not complaining, but I never addressed my other motion, which may in fact not be a motion, but
For a fair trial?
yes.
Okay.
But in the state's argument against Mr. Kendrick's motion, they're relying on King.
Right.
I would invite the court to.
And I think we're going to skip ahead a little bit here. So let me do this. Let's skip ahead some. There we go.
Said to Mr. Copeland, Mr. Garlington is charged in this indictment. He has he has a Fifth Amendment right. He's not on trial with us. I have no information that suggests that he's going to be testifying in this case. So he will not be testifying. So the state is attempting essentially to ask Mr. Copeland about statements he made to the police that of what Mr. Garlington told him, because there's no indication that Mr. Copeland himself has any firsthand knowledge or is a witness to any of this. Now, I have a separate concern about the way they're not laying the foundation for a prior inconsistent statement to play the videos, because Mr. Copeland is in fact acknowledging that he told the police. He's not denying making that statement. He's just denying the veracity of that statement. That being said, the statements themselves, how are they admissible? Because they're clearly hearsay. Garlington to Copeland. Copeland without firsthand knowledge. So
and he's talking about one of the people that were in the car after they killed Nutt.
As I understand it,
allegedly,
that these are statements by a co-conspirator. Thank you. They've always taken a statement that they're statements by a co-conspirator. In their filings recently, and I don't want to misstate this, they may have made this claim before, so I'm not going to say it was the first time to make this claim, but I noticed in their filings, they argued in the alternative that they're statements against penal interest as well. And they've provided cases, and I have just handed up my cases. Regarding co-conspirator statements, of course, and we're talking about hearsay and the confrontation clause. It seems to me their main reliance is on the Kemp case, where the Kemp case, as they want it to be understood, is that idle chatter or narrative of past events do not further a conspiracy, but narrative of past events are admissible if they serve some present purpose of the conspiracy, including statements made to solicit membership or participate in the conspiracy or to promote cohesiveness among or provide reassurance to other conspirators. And the reason I filed this motion is because in all prior discussions, the trial court completely glazed over the furtherance. I'm focusing on whether these statements furthered the conspiracy. Okay. The state's cases do not apply to this situation. The difference, and I'm referring to the Kemp case, United States v. Flores, which the state relies, United States v. Santiago, and U.S. v. Holt, all in their filings. There's absolutely no indication in the record in these statements that the alleged declarant Garlington was attempting to solicit the membership of Copeland in the conspiracy in any way. And I understand the states, in the case law, some of the cases indicate this, that, you know, you have a conspiracy, you got a small conspiracy and a large conspiracy, and statements in furtherance of a conspiracy could be furthering the large conspiracy. Okay, but soliciting membership, there's been no allegations whatsoever by the state. In fact, we've been talking about this ex parte motion ex parte hearing where they're saying that Mr. Copeland clearly had nothing to do with the murder of Donovan Thomas. They've fought to say that Kenneth Copeland had nothing to do with that conspiracy. So
that's true. They did
solicitation there's no evidence of anyone soliciting his membership in the conspiracy to murder Donovan Thomas. In fact, that had already occurred at the time that these alleged comments by Mr. Garlington were made. And if the argument is, well, they were trying to solicit his membership into a larger conspiracy, the YSL conspiracy as a whole, Mr. Copeland, according to the state, from the very beginning, according to their expert, Mr. Investigator Belknap, according to everything they've shown the jurors pictures of Mr. Copeland, videos of Mr. Copeland from 2012, 2011, 2013.
Land the plane, Max, killing me.
Where he's with these gentlemen, putting up hand signs, claiming YSL, all the rest. If the argument is, well, they were soliciting him into the larger conspiracy, he was already part of the larger conspiracy according to the state.
Okay, let me ask you this. So a part of the cases that the state cited,
She's not.
I mean, it may be that part of it was one way you can find this as a co-conspirator exception is soliciting membership, but another concept was to further the purposes of cohesion amongst, and I think they have gang cases, so a gang. Right. So can you address that?
Well, they have the burden of proof by preponderance of evidence to show that this has been furthered. There's been no evidence. Again, we're seeing pictures from over the years. There appears to be complete cohesion. There's been no evidence that this was done, if it happened at all, which my sense is it didn't happen, but assuming that the statement was made by Mr. Garlington to Mr. Copeland, this brief statement, I think we're really stretching where the exception is essentially swallowing the rule. If we just say, well, a statement about past events with absolutely no indication that someone said, hey, this is what we need to do. We need to be quiet. We need to do this. We need to do that. There's no indication that Mr. Copeland was instructed
That's a part
to
of
do
the
anything.
conspiracy. That's true.
Mr. Copeland just drove where he wanted to go afterwards. Now, I will say,
so basically his argument is that Lil Woody was his Uber driver. He was his Uber driver. He was in the back saying, hey man, something crazy just happened. Does that make you a co-conspirator? If you're an Uber driver and somebody in the back of your car tells you they just shot up a bank and they need you to drive them somewhere. Yeah.
The state's going to point this out that people on the street
something to think about.
Apparently thought Mr. Copeland was involved and began allegedly
retaliating
shooting up houses that he was associated with. But that has nothing to do with the purpose of the statement that allegedly Mr. Garlington made to Mr. Copeland. So there's absolutely, I mean, the record is just completely devoid of any evidence that supports that other than the statement themselves and just reading into the statement and just assuming, well, it must have been done for cohesion. But again, if we can just assume with nothing else, then what's the point of the rule to begin with?
That's a good point.
Mr. Copeland has never testified that anyone allegedly involved in the murder of Donovan Thomas has ever asked him to do anything. You know, the story that comes out through past statements are Mr. Treadwell takes a car somewhere to get rid of a car, to get rid of guns.
I mean, he said, I did these crimes. Does that count?
True statements, but that's what comes out in the discovery, and that's what comes out in other people's statements. Mr. Copeland has, it's completely devoid of anything that Mr. Copeland was asked to do. As far as also fostering cohesiveness, Mr. Copeland himself said that Mr. Garlington at the time was his best friend. So I'm not sure. In the United States v. Flores case, they talked about cohesiveness and cohesion within the group. And that was a situation where one individual, the declarant, was talking to another individual that didn't know. So you got the declarant, who ends up, and then another individual who ends up being the witness. We'll call him the third party. And then you have the defendant, and the declarant is telling the witness, hey, let me tell you about the defendant. He's a solid guy because this is what he did, and we're all one cohesive group. But the witness and the
yeah, she wants to do it the right way, Steph.
We're not close. They didn't really know each other. So the middleman, who ends up was the declarant, is kind of informing one person about the other and saying, oh, he's solid. We can be cohesive. In this case, Mr. Garlington and Mr. Copeland and Mr. Stillwell all knew each other very well. And that's come out in testimony. That they're, according to Mr. Copeland, they were the three best friends. So I don't understand how that falls under fostering cohesiveness, because there was already extreme cohesion between that group. So I think it's distinguishable in that aspect as well. US v. Holt, I'll just point out also, with all my other arguments, there's no indication in that case. It talks about keeping a co-conspirator abreast of the situation. There's no indication that Mr. Copeland needed to be kept abreast of the developments at the time. Mr. Copeland was not summoned to do anything by the group. Mr. Copeland called Mr. Garlington wanting to find out where he was. So it wasn't a situation where the group, assuming these statements were made, called Mr. Copeland to bring him in. Oh, can you pick us up? Can you do this? Mr. Copeland reached out to them. And also I'll point out that US v. Holt was argued under or decided under the plain error standard because the trial attorney did not object appropriately.
All right, land the plane, Max. Killing me.
I have the 4 cases I handed up, US v. Blakey. Well, I'm sure the court will read the cases, but State v. Wilkins I thought was particularly informative. It's a Georgia Supreme Court case. Trial court made a pretrial ruling excluding incriminating statements made by the co-defendant had been tried earlier. Trial court held that while statements were made by a co-conspirator, they did not further the conspiracy, and the trial court did not abuse its discretion. And it goes through all these different statements that the declarant co-defendant made that were basically spilling the beans and did not further the conspiracy in any way. State v. Lane, same thing. And that one, it's interesting. The appellate challenges the murder conviction, and the trial court granted Lane a new trial. The allegation was, the appellee, the defendant, hired Stallworth to kill a gentleman named Mr. Perez. A witness named Thompson testified that Stallworth told her about the plans to hit a lick before the killing, and then afterwards said that Lane did not pay him because he killed the wrong guy.
That's
crazy. The trial court initially at trial let the statement in, but then at the motion for new trial reversed itself, saying that in no way, in no stretch of the imagination was this statement made in furtherance of the conspiracy. A statement merely spilling the beans, disclosing the scheme, or informing the listener of the declarant's activities are not a statement in furtherance of the conspiracy.
And we read this yesterday.
Points to no evidence that suggests that by these statements, Stallworth was seeking to solicit the help in conducting the scheme or concealing its existence when he made those statements to his girlfriend.
That's true.
Those are the cases that I rely on. I also provided Stafford v. State, which is a little different because that was made to law enforcement. It supports my proposition generally, but it's a little different because it was made to law enforcement. Would you like me to address the statements against interest while I'm up here?
Is that in this motion?
Well, no, I understood the state's reasoning for the admission of these statements.
The penal interest? Yeah,
Yes.
Go ahead. Yes.
So I'm confused on how this is against Mr. Garlington's penal interest to say they killed someone. It's a hearsay statement that inculpates the accused is admissible if the declarant is unavailable. Okay, I can see that. The statement so far tends to subject the declarant to criminal liability that a reasonable person... Gotcha. I'm sorry. That would subject the declarant to criminal liability that a reasonable person in his position would not have made the statement unless he believed it to be true, and the statement is corroborated by circumstances clearly indicating its trustworthiness. My main objection is number 2, although I do believe that the statement is not corroborated either. But prong 2 it was not the type of statement that tends to subject the declarant, in this case, Demekion Garlington, to criminal liability. He said they did it.
And they're trying to loop him into the conspiracy.
A reasonable person could, how it could be said that a reasonable person would feel that saying they did it would put that person in legal jeopardy. As we know, as the pattern charges tell us, knowledge of a crime, mere presence, but certainly knowledge of a crime is not enough to convict anyone. And again, he did not say that he had any part in it. He did not say he played an active role. Additionally, Your Honor, I would point out the Williamson case that that I provided. And the Williamson case is, I believe it stands for the proposition that if you find any part of Mr. Garlington's statement to be self-inculpatory, which I don't believe it is.
Self-inculpatory. Oh my
Williamson
gosh.
dealt with a situation where within a statement there's inculpatory and exculpatory segments of the declarant statement. And Williamson says you have to deal with the pieces of the statement individually, and you just can't say, well, there is some inculpatory parts of this statement, so therefore it's all allowed in. You have to excise out the self-exculpatory areas within the statement and the neutral areas within the statement. It says 804B3 only extends to self-inculpatory statements and not self-exculpatory portions of a larger inculpatory statement or to aspects that are neutral.
I'm trying to find it. Exculpatory.
Neutral as to interest. Self-exculpatory statements are exactly the ones which people are most likely to make when they are false, and mere proximity to other self-inculpatory statements does not increase the plausibility of the self-exculpatory statements. And for the record, that's Williamson v. State 512 U.S. 594, 1994.
And it is self-exculpatory refers to statements or evidence that a person provides to clear themselves of blame or responsibility for a crime or wrongdoing. Essentially, it's anything that helps prove one's innocence.
If there are, which I don't believe there are, any inculpatory parts of Mr.
Oh, there you go. Amy's got it too.
Mr. Garlington's statement, the exculpatory or neutral aspects of that statement need to be excised out. And I'll point out that if you listened, and I know Your Honor did listen, but I mean, I've listened to these statements 15 times, 20 times at this point. It's very unclear to me where the source of some of, we're assuming a lot of it's coming from Garlington, but it's really unclear where Mr. Copeland is claiming to have received some of his information and when he received some of his information. So that makes this task difficult. I think that absent a showing that the state can meet their burden under 801D2E or 804B3, that none of it should be admitted. But certainly, if we were going to admit some of it, we would have to excise out the parts that are not self-inculpatory, including, but not limited to, the part where he's pointing at other individuals and say they committed a crime. So those are my objections. I think if they come in, that it violates hearsay as well as the confrontation clause.
And what's your confrontation clause argument? Because we haven't really touched on
well,
that so much.
Mr. Garlington's the source of
he makes some good points though
information, and he's not going to be subject to cross-examination. He's not testifying.
All right.
So thank you.
Thank you. Who's arguing this for the state?
Oh boy, here we go. see what the state has to say about this one.
Judge, I will, of course, stand on, not stand only on, but stand on the response that we have filed. I would point the court's attention starting off to page 3 of our response and the second full paragraph on that page, Your Honor, where we are giving some facts of the case wherein it's already been shown at trial that a few days before the murder of Mr. Thomas, Mr. Copeland said that he was with Defendant Williams when Defendant Williams rented an Infiniti from a rental facility at the Atlanta airport. That same Infiniti, we allege, was utilized in the murder. Evidence at trial has already proven that Defendant Williams did in fact rent an Infiniti Q50 on January the 7th and returned it on January the 11th. Testimony at trial has already revealed Mr. Thomas's participation in Mr. Thomas's standing as a high-ranking rival Inglewood family blood gang member to the YSL criminal street gang. The week before, as Mr. Thomas was murdered, Mr. Copeland was physically assaulted at Club Crucial.
Yeah, they tried to run his pockets.
And
poor little Woody, man, he can't catch a break.
Multiple YSL gang members, including Mr. Copeland.
Slow down.
I apologize. Including.
And y'all start reading instead of talking. Speed up. All right, go ahead. So in
the early morning hours after the murder of Mr. Thomas, multiple YSL gang members, including Mr. Copeland, Defendant Williams, Mr. McMullen, Demekion Garlington,
all of them, and Lil Woody named all of them too.
Shannon Stillwell fled to Miami, Florida.
Crazy.
And after these members of YSL returned to Atlanta, there were a number of retaliatory shootings between YSL and IF gang members. So just to sort of encapsulate that, all of that, when Demekion Garlington alerted Kenneth Copeland that they just killed Nut, he was alerting Kenneth Copeland to the fact that a high-ranking rival gang member has just been killed by our guys. And it's important for us to now prepare, protect ourselves, and flee to Miami.
Yes, sir.
A lot of this is not, and I put in writing, I'm objecting to any proffer of Ms. Love. A lot of this is her theory. It is not what the evidence has shown or will show.
Okay.
Brian's still trying to rile him up again.
Ms. Love, are presenting this as what the evidence has already shown.
Part of it.
She said part of it.
Saying now, I specifically say when I mean to say that the evidence has shown.
Okay, so the evidence has shown that Thomas was a high-ranking person in a rival gang.
Yes.
That the week before Mr. Copeland was assaulted by Thomas's brother.
Yes.
That in the early morning hours after the murder, Mr. Copeland was amongst the people who fled, the group of alleged YSL members who fled to Miami. That's established already?
No. So that will be established.
Okay.
I did not assert that testimony at trial has revealed this, but I am asserting that it will be established.
Your Honor,
who all has.
If it matters, it was not in the early morning hours. Mr. Copeland's phone records, if you go by phone records, will be several days later.
Okay. Thank you.
Excuse me, Your Honor. I object to the language of it's already been proven in here. I don't mind if she says that there's been evidence that's been submitted, but already been proven, I think, is too much.
Noted. Agreed. That's not for us to decide. That's for the jury to decide.
Okay.
So, Ms. Love.
Our position.
That's fine.
They're making a comeback.
Is fine. But what, so is your
evidence going to show that Mr. Copeland went to Miami in the early morning hours after the murder, or is it going to show that several days later?
Not several days later. I believe it was actually, I know that, was it the next day? I think it was the next day that.
The murder was
January 10th.
Okay, and he went to Miami.
And then he was in Miami.
Miss Love's doing pretty good so far. I think the state, they're holding their own right now. They're up 5-2-2. We'll just see how long she's going to stay on this case.
While the state's doing it, if you really care, it's January 6th is the alleged beatdown.
Okay.
Mr. Copeland, it wasn't a week earlier. January 10th, it's going to be January 6th. It's at the club.
Okay. Thank you.
Crucial. It's a comment.
It was the Sunday before, Your Honor.
Okay.
And so the murder is January 10th in the evening. Some YSL members arrived in Miami on the 11th. Mr. Copeland arrived in Miami on the 12th. So the departure from Atlanta by some was hours after the murder. Mr. Copeland gets there on the 12th.
Okay, and do you have evidence that they all congregate together?
Yes.
In Miami? Okay. Okay, and does he...
You got to remember, rival gangs are the victims here.
Anybody else on his trip to Miami? I'm just curious.
Just 1 second.
Testified after the recusal motion that he traveled to Miami with his girlfriend or the mother of his child and his baby.
All right, thanks.
And also, my understanding, and I believe it was testified to, it may not have been, was just to, when we're using the word fled, is that Mr. Williams had a show in Miami.
Okay.
Yep,
So,
and Varian caught it too.
Mr. Copeland, I believe, has testified already that they were collectively in Miami.
Okay.
Aren't we getting rid of those testimonies though? Isn't that what she said earlier? So how can we? Oh man, what a mess, man.
Specific question of who he went down there with.
When did he testify to that?
We don't assert who he specifically went down
together once down there. And when did they come back?
They came back at different
He must have testified in one of the interrogations, but that's not testifying. What is she talking about?
A couple of days later? I mean, just give me a ballpark.
They came back at different times.
Okay.
Different times.
All right. And was there a show for Mr. Williams down there? Some kind of a music show, I assume?
I'm saying, Variant, broken, like
that we have
shattered glass.
That's not evidence that we have, or we have put in. That's not evidence that we have.
Yeah, how is she using Lil Woody's testimony when the judge just ruled that we're throwing out all of Lil Woody's testimony? You can't say Lil Woody testified to this, but at the same time, we're not using this is
that might be some.
And there was so just to also clarify, this vehicle that was rented, it was rented for a number of days. It was supposed to be returned, I believe, 3 days after it was returned. So they returned it early. They returned it on the 11th instead of returning it later in the month, as it were. I think, as I said earlier, I believe it was returned about 3 days early. If there was a show, Mr. Williams was aware that he was going to be attending at a particular time on the 11th, the need to keep the car, unless they intended to drive the car to Miami, I would assert, should have reflected itself in the way that he secured the rental. If he intended to be at a show, then
what date did he rent it?
He rented the Infinity on.
So what is she doing right now?
January 7th, I believe it was.
Thank y'all for liking the video too. I appreciate it.
And he returned it on the 11th.
All right.
And the already admitted at trial is the rental agreement that shows that it was due to be returned later after the 11th.
So it was probably a week rental?
Actually, Judge,
maybe. Okay. Whatever.
So
you
week
said a few
case.
days early, which, okay. All right. So back in the Atlanta area, there is a series of retaliatory shootings. Is that in evidence, or is it going to be in evidence?
That has been already put in evidence, and additional information regarding those.
And is there any evidence that Mr. Copeland was involved in any of those shootings?
Yes.
Back and forth. Okay. Between YSL and whatever the gang is that Mr. Thomas.
IF.
Okay.
Yes.
All right.
Specifically, if I may, there were instances that were testified about regarding a particular shooting. So right after the murder of Mr. Thomas, there were a number of shootings that Mr. Copeland was very concerned about and spoke about when he spoke to police in the early morning hours of the 11th. When he himself went down there, he essentially said to them, and I believe that the court has the recording of Mr. Copeland's first interview, they're shooting at me. They think I did it. They being Ifke, they think I did it.
Why do they think that?
So his girlfriend's father's house was shot up. His brother's house was shot up. Mr. Williams's father or stepfather's house was shot up. There were a number of shootings
everybody
that
got
have
shot
already
up.
been testified about.
All right. All right.
So just to start with the assertion regarding cohesiveness, that it's not so much a situation where we're asserting that someone is trying to bring Mr. Copeland in to the fold. He's already a part of it. And in alerting him to this happening, this event, he's including Mr. Copeland in on what's going on with the gang. This is our position, so that Mr. Copeland can comport himself appropriately.
All right.
Okay.
We have noted in our response that when we are talking about a conspiracy, it's not just the conspiracy, it's not regarding the conspiracy of the murder of Donovan Thomas only. The conspiracy is the wider, broader participation in YSL, and the criminal conspiracy is alleged in count 1.
And Ms. Love, is it correct that Mr. Copeland also said to police that after the first revelation that they shot Nutt by Mr. Garlington, that and that was in the McDonald's parking lot, that either they did or they were then instructed to follow The car that had apparently been involved or allegedly been involved, follow that car to another place where they all spent the night?
Don't look at Hilton. What happened? Let her tell what happened.
And that he did so?
Okay. We're trying to make certain that the court is hearing that it's Mr. Treadwell's vehicle, not the Infiniti.
Okay.
That they are following.
So this is not the rented vehicle.
Okay. But the vehicle that Garlington apparently indicates when he says they shot not means the people in that car.
Yeah, the Nitro, yes.
Nitro, okay.
Yes, the Dodge Nitro.
Okay. And they then
followed the Dodge Nitro.
Mr. Copeland follows the Nitro.
Yes.
And is he directed to, according to him?
According to him, that's love.
I don't know
not
what
you.
he says.
Okay, well, anyway, he follows the Nitro, and they all spend the night together at an apartment that Mr. Williams has in Midtown.
I don't know that they spend the night. They end up at Mr.
I don't know whether they did either. I'm asking what Mr. Copeland said happened.
That they all go to the home of Mr. Williams.
Okay.
This is yet another reason why this is a mess.
I can assert what I expect other evidence will show that has not yet been shown, but other persons that we expect will testify during the course of this trial will also say.
Yeah, let's wait until then.
Met at Defendant Williams' condo, and as reflected in some of the factual acknowledgments of some of the persons who have already entered negotiated pleas in this case, they were given money to lay low. Members of YSL were given money to lay low following the shooting of Mr. Thomas.
Okay. All right, and so your theory is that...
Where was that? When did that happen?
Go ahead.
In alerting Mr. Copeland to what just took place, it furthers cohesiveness. It lets him know about a significant event that just took place that involves members of the gang itself that he needs to be aware of. He needs to be alerted to so that he can act accordingly.
It says, how can the judge rule on anything that has to do with Lil Woody's testimony when the judge said all of some of his testimony may be thrown out? That's what I said earlier.
Argument. I mean, I think that
everything that Woody said is gone.
Kind of a good point that how can it be against Mr. Garlington's
give me them cookies
to say somebody else did the shooting?
It wasn't just the shooting. He also, Mr. Copeland, that he has also talked about Mr. Garlington's words to him regarding his presence and his knowledge of who it was that participated in the Lil Wayne bus shooting as well.
Okay, so this is an entirely different shooting.
There were two, yes.
Right, so let's focus right now on what he said, the hearsay about the Thomas shooting.
Okay.
How is that against Mr. Garlington's penal interest?
It's Mr. Garlington, as we said, is providing information about we argue, a gang-motivated crime committed by members of the same gang that he is a member of. So in saying what he did, he is talking about actions committed by, I would argue, co-conspirators. He's a member of the same criminal conspiracy as those that he's called murderers and shooters in the Lil Wayne incident. He is, given the context of his relationship, his being Garlington's relationship with Stillwell and the other YSL associates that he names as having killed Mr. Thomas, he had no reason to lie about the murder or the shooting. He would not be privy to the information that they just killed Nut had he not been a part of that same gang that these persons that he alleged have just killed Nut are also parts of.
All right, so is your theory then that when he says this, it reveals that he's a part of this same gang and therefore he can be charged under a gang count?
No, he has information.
I don't know what she's saying either.
Involvement. So it's not just that. It's not so much that he can be charged under a gang count.
A statement against penal interest would require that what you say could get you arrested and convicted of a crime, right?
Correct.
So how is what he said going to do that?
Good question.
It is evidence of his membership in
I don't know,
criminal conspiracy that is YSL.
So he's a co-conspirator.
The act that they have committed is evidence that this enterprise commits criminal acts. It subjects him to punishment under count 1 in our indictment.
So as a RICO.
Okay, so basically what I'm hearing she's saying is, for example, somebody sells a bunch of weed to one person, and then that person is a part of a bigger organization that sells weed. So now she's saying that because this person sold weed to that person, that he's a part of this bigger RICO organization, YSL gang. I guess that's what I'm seeing.
Not even a gang charge, a RICO charge.
A RICO charge and a gang charge, to be clear, because in our case, the RICO charge.
What's the constantly seeking truth?
Involving the criminal enterprise that is YSL, the criminal street gang.
Being affiliated.
Mr. Garlington is a member of YSL, the criminal street gang. Part of what is necessary to prove a criminal street gang even exists is the fact that members commit crimes to further the interests of the gang. He is acknowledging that a group.
What's up, Shar?
That he is a member of commits these type of crimes that he is talking about. That acknowledgement can subject him to punishment for acts that he commits as part of or in furtherance of the criminal
for acts
street
that he commits. He hasn't, by this particular statement, admitted to committing any acts, right? He's saying somebody else did. All right.
That's as it relates to the
She's saying he is because he drove the car and he knew stuff about it.
Okay, anything else on this?
It's the only thing I could see.
Just 1 second, Your Honor.
Appreciate you, Shar. The reason here she's able to share her theory is because she's going to use this at a later time to prove her point. So the judge wants to know where she's going with this and understand how she's going to use the evidence that they're trying to keep out. That's the whole reason she's able to be so long-winded here. Great question though, Shar.
And Your Honor, the fact that Mr. Garlington is alleged to have been, according to the statement, with them when they drove by and saw Mr. Thomas. Before
exactly, Unagi. Your Uber driver is going to be caught up in a RICO.
Reflects his involvement in the gang itself.
Okay. All right. Sure.
And Judge, if I may, before Mr.
She's not.
Go ahead.
I hope she is. Good
I
Lord.
would cite the court to United States versus Padilla, P-A-D.
Is this a new case that's not in your response?
It's not.
Okay. All right. USV Padilla.
Yes.
What's the site?
Yeah, of course, Char. I appreciate you.
2000 US APP Lexus 1843 at
Yeah, she's I'm not buying what she's saying. It seems like she's trying to put pieces together that aren't
At
really
what?
there,
Page 5.
even from a legal standpoint.
All right, 2000 USAPP Lexus 1843 at 5.
Yes.
Okay. All right.
Wherein the court says that we reject the arguments of Padilla and Rodriguez that the district court erred in admitting plea allocutions of 5 co-defendants. The district court found that all of the co-defendant statements being admitted into evidence were self-inculpatory, involving inter alia admissions of membership in the named RICO conspiracy, and the court declined to reverse the district court's finding as an abuse of discretion. So in his statements, we would argue inculpate him in the RICO conspiracy.
Oh my gosh.
Stop the cap.
Stop it, man. This is killing me. She's killing me. There's no way. I'm not seeing it.
Okay.
I'm not a judge. Again, I'm just a regular person, but that was brutal. Absolutely brutal.
John, I think it's clear that this is not a statement against penal interest.
It's clear to me too.
You know,
come on, Max.
What a reasonable person would believe. And, you know, to come up with these theories about RICO conspiracies when you haven't done anything wrong, I just
it's
don't
a conspiracy
see that
about a conspiracy.
that exception to the hearsay rule. Regarding the statements, whether they're in furtherance, you asked, was he directed? The answer is no. He called Mr. Garlington. Mr. Garlington said, hey, and this is before making any statements about the alleged murder. Apparently he said, you know, can you come pick me up? Sure. He went down there. A statement, we say it was never made. Mr. Copeland now says it was never made, but regardless, the statement, if it was made once Mr. Copeland gets down there. He's never directed to do anything. He just goes and follows people that he knows. The state is arguing that narrative events given so someone can comport themselves appropriately makes a statement in furtherance of conspiracy. And if we just logically think about that, that would mean that any time there's a declarant and someone else and a witness who are allegedly involved in the same conspiracy or in the same gang or anything else, anytime a statement of narrative events is made from declarant to witness and they're linked together in any sort of alleged gang or conspiracy, by definition, it would fall under this exception. And that's just not the case. The state is saying so he could comport himself appropriately. They have no evidence of that at all. That's just their theory. And it's just a blanket statement to say that it fits under these cases, but it's not backed up by anything. And, you know, if we were to just allow those spilling the beans statements in under that just imagined alleged basis, then the rule really doesn't even need to exist, and the exception would swallow the rule. So it doesn't fall under either of the exceptions asserted by the state.
All right. Thank you.
I'm with Max on this one. This everything she said was absolutely ridiculous.
Yes.
I just point out that the cases that were cited by defense in support for their position, those were not gang cases. Ours specifically, the cases that we cite are gang cases. We cite a plethora of gang cases. And in doing so, we express how here there is a distinction between the case that we have and the cases that they are citing, and that we are specifically talking about the criminal conspiracy of the YSL street gang. The argument that any statement made for a narrative purpose would be admissible is inapplicable here, where the statement that was made was not just any statement for a narrative purpose. It was a statement about a criminal act committed by a co-gang member, a co-YSL member or members of the enterprise that this young man, Damikion Garlington, is alleged by the state and we believe can be proven to also be a member of. Additionally, we will be at trial later on presenting evidence from other sources of what took place at that condo, which further show what we are arguing here.
All right. Let's break for lunch. We're probably a little bit on the late side for breaking for lunch,
Jenny?
but it is 12:35. Let's come back at 1:45.
All right, looks like we got our first break. There it is, y'all. Our first.
Mr. Steele, I'm going to give you your copy of that
Whoop, hold on.
transcript back. Thank you for loaning it to me.
Okay, there it is. First official breakdown. Live. Wow. They said we're going to be back at 1:45. We are not going to be here, but y'all know we'll be covering this trial as these next few days go on. Tomorrow is going to be very, very interesting. We're going to see what happens with Judge Whitaker deciding, one, do Love and Hilton stay on? And two, is there going to be a mistrial? I am so interested to hear what y'all want to say. I'm going to go ahead and open up the phone lines here for a minute, and then I'll get y'all up out of here. So let me make sure we're good. Double check the settings there. And shout out to y'all for hanging in there, man. We had almost 200 people in here the whole time. I appreciate y'all staying locked in and showing love. Let me see what the chat is saying. This is wild. And also, I'll be dropping some clips from these from the live stream today later on for y'all as well. We'll probably drop a couple. I might drop one here when they come back from break, actually, and then we'll drop another one this afternoon and tomorrow. Constantly seeking truth and light, the new timer in the building says this is funny as fuck. Love is babbling about, I don't know. She's so incompetent and she is a ball of confusion. She doesn't even know. And the judge was like, F this, I'm exhausted. She was talking in circles. I don't know what, like a NASCAR driver, I guess. Variant says she didn't want to hear another word from Love. It was bad. That was rough. Mara is in here, says, what's up, ClassE? What's up, chat? Good to see you, Mara. Appreciate you stopping by. Jenny D says, Love is a mess, and it's great to see. I don't think she gives. I don't see Judge Whitaker letting this slide. Because I get where the prosecution is trying to go in this case, but still, it seems like a big reach for you to say that the Uber driver was friends with the person who shot up Big Nut. And because they called them for a ride and said, hey, can you just take me to McDonald's? If you want to hang out, we can hang out afterwards. And then you're saying they're a part of a conspiracy? Come on. Please. Please, please, please. What else are y'all saying? Everybody's saying what's up tomorrow. Constantly seeking truth light says, I guess I need a membership. Like the chat vibes. Appreciate you. Yeah, we do our thing over here. Roro says, be back in 30, not a minute after. Yeah, you know she's going to be ready to go at 1:45. I don't think we had anybody who wanted to call in. So if we do this tomorrow, y'all let me know. Do y'all want to do this in the morning again? Because tomorrow could possibly be a big day. And I know we've got a lot we've got to cover too. Because this afternoon, I'm sure, I have a feeling that Judge Whitaker, she's got a lot she's got to look at, especially when it comes to Love and Hilton and the mistrial. So she'll probably come back. She'll hear a little bit more. She'll make a decision on this motion from Max Sharp. and then she'll finish up the day. So we shouldn't have anything crazy happening today. Shout out to Mar. That was the wrong one. With the super sticker over there, dropping the 199 to 2 bomb. I appreciate you, man. I do not ask y'all for super chats, but it does mean a lot that y'all show love and support the channel. So thank you. Thank you. Thank you. No, we're going to be here. We'll be there. Amy saying report to her office. Uh-oh. Hey, yo. You talking to me? Oh, she's probably talking about Judge Whitaker. Roro says yes, she is reaching, leaping, and stretching. Still got Love flustered, and there were at least 3 objections while Love was talking too, which was great to see. Mixed Chick Samantha says my brain is tied. Her brain is fried. Truth. Shout out to Shar. Says yes, great coverage and great chat. Shout out to the community, man. Yeah, we're gonna do it. We'll be back in here in the morning. I guess we're just gonna have to move the morning show while this trial is going on, because I'm enjoying listening to and breaking these down live. If the only reason I won't go live and break it down is if I see the lead attorney goes live, because the lead attorney, he has the most experience out of anybody I know in my inner circle and in my group. So I want to hear what he has to say over me sitting here talking about it and speculating. So if he goes live in the morning, probably won't cover it, but I'll keep y'all posted. If you're a member, and even if you're not a member, make sure y'all subscribe, because I'll be dropping updates over on the community tab on the ClassE Beats YouTube channel, and letting y'all know any updates we have about the trial, anytime we're going to go live and make different changes there as well. All right, let's get a couple more comments in here and I'll get y'all up out of here. Roro says great coverage. I appreciate it. Shout out to Roro. Jenny D said it's true. He's amazing. All right, y'all don't gas me up now. Oh, she's talking about the lead. Okay. Yeah, shout out to the lead. He's the man. Hollywood Coast says road to 35K. We'll be there. We'll be there in a month or so. I can see it. Lead is the man. We got to put some respect on his name. I was he was live streaming last night, and I was asking him about going live this morning, and he's like, nah, I'm not doing it. Y'all go ahead and handle that. He's retired. And Hollywood Coast said Javier and Bailey is our lead attorney. Yeah, and we'll be able to talk to Javier sometime this week too. So y'all make sure that you stay locked in and subscribed as well. Variant says, where will we watch when you leave? Oh, shout out to Variant. I can drop the link if y'all want to continue to watch this trial after I leave. I'm dropping the link in the chat for you right now. This is Law and Crime Trials. Also, I think Infamous Sylvia is actually in the courtroom and live streaming it herself as well. So you can go and watch it there. And I think we're good. All right, y'all. We are going to be back tomorrow right here. I'll say 8:55, 9 a.m. Eastern Standard Time. We'll have another episode. We'll do this live. I definitely want to see what's going on with Judge Whitaker and what she decides to do with this case moving forward. So it's going to be interesting to see what happens. Oh, we got the screen glitching a little bit. And then, of course, tomorrow night, we've got another episode of the Song of the Night Live. If y'all want to tune in for that, we will be live tomorrow night at 8 p.m. Eastern Standard Time as well. I appreciate y'all. Make sure you like the video on your way out if you haven't liked the video. Hope y'all have a great rest of your day. Make sure you subscribe. Look out for a couple videos we're dropping later today. And I will see y'all on the next live stream. Appreciate y'all. Keep growing. Keep pushing. Keep it classy. Peace. Mixed Chick Samantha say, you providing lunch? Oh, hell no. Now y'all on your own there. Peace.